Transfer.
Pardon to mention, my lord. Resolution item 17. Mr. Mahanti is expired on 13 July, my lord. 13 April, my lord. Kindly taken up after interim order, if any may continue till next date, my lord.
If anyone, are you aware of any interim order?
Well, I have no knowledge, but he is expired, my lord. I have no file, no.
Who are you?
I am a lawyer's man.
You are a lawyer, that I know, but are you his associate?
No, my lord, I am engaged in many cases.
All right. So we'll have to issue a notice to the petitioner because his counsel.
No, my lord, his family were in Freemason, दशा फरी नहीं जाए सर तांको रजिस्ट्रेशन लेबु हम एफआईआर करिबु.
Okay, what is your good name, sir?
कीर्तन बढ़ई.
Yes,
कीर्तन बढ़ई. कीर्तन बढ़ई.
the Kirtan Bodhi, learned counsel appears and submits that the previous counsel, Sri Somadarsan Mahanti, has expired in the meantime. And that he may appear for the petitioner. Okay. He requests for adjournment.
Accepted, madam.
Vacation for Let's this matter after summer vacations.
I may prayer, my lord. I am having a partner matter likely to continue sometime in the Honorable Chief Justice Court. Item number 12 and 19 likely to, if necessary, be passed over, or I know my habit on Monday.
Not Monday. It can come only on Friday. Monday, other matters are fixed accordingly every day. The partner matters are fixed in the corresponding day of the week. If you want, I can adjourn it. But who appeals for the other side, sir?
Other side is state.
Other side is state. Okay. We'll adjourn it to next week. As requested, let's this matter next week, next Friday. Then 19.
Yes, ma'am. Today is 19. My lords may.
No, item 19.
12 and 19.
Yes, that's what I'm saying.
And maybe
item 19 is also,
yes,
state is a
state. They have to file counter. They have not filed. I do not want to burden them on that day. They can also. Because they have asked
let's this matter on release this matter next week. Counter affidavit, if any, be filed in the meantime. Yes.
Subjected to
next week, next Friday.
Next Friday.
26. Item number 25.
25, yes. Yes.
Lord, I have some difficulty, Lord, today.
So this is a 2016 matter.
Yes, Lord. It has come and mentioned also.
Yes.
So, Lord, I am ready to do it on Monday also.
Monday? No, not Monday. That is the problem. If I adjourn it, it has to be adjourned for at least a week. So that is the problem.
1 week after you will also, I will come with the notes and everything. I am for the appellant. I will inform the council, my lord.
You inform him?
My lord.
Sri S.K. Das, learned counsel for the appellant, for an adjournment. Let's this matter next week? Next Friday?
Lord, 1 week after, not on 26th.
3rd May. Since this is a case of the year 2016, parties are requested to come ready for final disposal, for hearing.
Yes, Lord.
Yes.
Pardon to make a mention, Your Lordship. Item 72 of your Lordship's list, weekly list. May I pray for the matter to be taken up coming Tuesday, Your Lordship?
Item 72.
Item 72 of the weekly list.
All right.
My Lord
Next week.
Senior is also.
Next week. That matter which you were mentioning.
We are mentioning that it be on
Next week it will come next week, not Tuesday. It will come in the weekly list.
My lord.
Weekly list, any day it can be taken up.
Taken up. My lord.
It can be taken up.
Fix a date, then it becomes.
No, I can't fix a date, sir, because if it comes in the weekly list.
My lordship would keep it on Tuesday, it will come on the supplementary list.
No, the supplementary list, if it comes, it will completely upset the apple cart. That's the problem.
At the top of the list.
You see, basically, this is now it has become a miscellaneous bench. Quite a lot of different kinds of matters are coming. So I'll have to adjust accordingly.
My lordship, please.
So it will come in the weekly list. If you want to make a mention, you can make a mention on Tuesday, and in fact, it will reach on Tuesday. It will reach on Tuesday itself. Because today, if it is 72, and next week also, I'll be bringing some second appeal matters in the weekly list. So bail matter will be slightly reduced. So it will definitely reach.
Preferably Tuesday, my lordship already said.
Yes, it will, don't worry, it will just make a mention.
No.
Just make a mention, it will be taken up. Yes.
Item 18 in supplemental list, my lord. Item 18.
Yes.
The last occasion, let's say directed to take instruction about this matter, my lord. I have not taken, can take on next week, my lord.
Let it reach. Let it reach. Just wait.
I may pardon my lord.
Yes.
My lord, 3 TRP matters have been filed by the in the matrimonial case. Husband has filed one case to transfer the matter from Sambalpur to Bhadrak, but wife has filed 2 matters at Bhadrak to transfer the husband's matter from Sambalpur to Bhadrak. I am ready to contest the matter at Bhadrak. That's why I want to withdraw my case and also to allow the case of my wife.
So they have not been listed today.
It will be listed. It has not been listed. Let it be listed on any day.
We file a memo. File a memo. I'll see.
I have already filed the memo.
All right. I'll see. Yes. Yes.
List item number 1 for delivery of order.
For the foregoing reasons, therefore, I am inclined to allow the prayer for bail. Let the petitioner be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following condition. The petitioners shall furnish cash security of rupees 20 lakhs in all, of which rupees 5 lakhs shall be paid upfront at the time of release, and remaining rupees 50 lakhs shall be paid in 15 installments. Such deposit shall be without prejudice to the rival claims. The bail appeal is disposed of accordingly.
Okay.
Item number 2 for delivery of order.
For the foregoing reasons, therefore, I am inclined to allow the prayer for modification by modifying paragraph number 5 of the order dated 11/12/2023 to the extent of substituting the same by the following paragraph. Considering the nature of accusations and also the materials on record, while not being inclined to grant anticipatory bail to the petitioner, the ABL appeal is disposed of, granting liberty to the petitioner to appear before the court below and move for bail, which shall be disposed of on the same day in the first hour. In case of rejection, it shall be open to the petitioner to move the higher forum on the same day, for which the records, including the case diary, shall be transmitted at his cost. The higher forum shall also dispose of the bail application on the same day. The IA is accordingly disposed of.
Item number 3 for judgment.
Item 3. Yes. For the foregoing reasons, therefore, the writ application is order under Annexure 12 is hereby quashed. The opposite party authorities are directed to issue necessary order of appointment in favor of the petitioner in the post of Shiksha Sahayak as advertised, or in any equivalent post considering his qualifications without any further delay, and in any case within 4 months from the date of communication of this order or on production of certified copy thereof by the petitioner.
Item number 4 for judgment.
For the foregoing reasons, therefore, the writ petitions are allowed. The opposite party authorities are directed to grant TVS scale to the petitions from the date of completion of 15 years of continuous service, and second ACP from the date of completion of 25 years of continuous service, along with arrears admissible within a period of 4 months from the date of communication of this judgment or on production of certified copy.
Item number 5 for judgment.
For the foregoing reasons, therefore, the writ petition is disposed of with direction to the opposite party authorities to issue order of appointment to the petitioner against any available equivalent post notionally with effect from 17/11/2018 and to pay 50% of the salary that would have been admissible from such date till the date of her actual joining without any further delay, and in any case within 4 months from the date of production of certified copy of this order by the petitioner. Consequently, the orders under Annexures 12 and 13 are stand quashed.
Item number 6, press admission.
You pass out.
Item number 7.
Item number 7, my lord, I am for the wife petitioner filed transfer petition, and the husband has filed a divorce petition before the Judge Family Court of Bhubaneswar,
Yes.
and the petitioner filed the case and they transferred the CP case from
Will be
Bhubaneswar.
corrected, Mr. Acharya. There is some corrections are necessary. You'll get it out as soon as possible. Huh? I'll just correct it. I was just even now also I could see some mistakes there.
ठीक तो देखी देखी पड़े बोले करेक्शन वाले ठीक है
No, there correction. Yes.
Transferred the case from Judge Family Court of Bhubaneswar to Judge Family Court Cuttack.
Why?
On the ground that the petitioner is a branch manager posted at Cuttack.
What Cuttack? Sir, why should there be
Punjab National Bank, what happened, my lord? Her father is died, mother is living with her, and son is studying in standard 4 at DAV public school.
though he is a branch manager posted at Kotak, it is not practicable in each date to appear before the judge family.
You can appear through virtual mode.
And
You can appear through virtual mode. People are appearing from Bangalore through virtual mode before the family court Bhubaneswar. You can appear.
sole problem is virtual is not
No, no, it is functioning. No. Don't tell me that. I know it is functioning.
Let it be admitted issue notice.
No.
So it's a responsible,
There is absolutely no reason to transfer.
a responsible post as a branch manager.
No. So what?
In each date,
No.
my lord knows in each date in family court, each date the party should be appear.
No, there is no such thing. There is no such thing. Again, if you want, I can pass such an order that her personal attendance shall not be required on every date. Wherever it is absolutely necessary, she can appear.
Yes, at the time of
And at the same time, you can appear through virtual mode. So,
virtual mode is not possible. Even if Kotak is virtual mode is not practical.
no, it will be.
My lord knows that everywhere is virtual mode, but in Kotak is not also practicable.
It will be done. Don't worry. The petitioner.
Yeah. And therefore, I pray let it be. No, other side may be appear.
No.
This
Other
whole
side.
problem only son is reading here. He is residing. My lord, I have already annexure 1 is my rent agreement executed by the bank. Annexure 1 running page 6.
Kotak Bhubaneswar, these are twin cities. And virtual mode is available at both places. You may say so that sometimes, maybe someday, it may not be functioning because of the internet problem. But otherwise, Kotak Bhubaneswar transfer hame kariba case thala bhabibo kon agi. The petitioner, wife seeks transfer of the CP number 798 of 2023 pending before the judge, family court, Bhubaneswar, to the court of judge, family court.
One. It's 2 is lekha itanta. Someone my lord have a glance to the
Bracket one.
one.
It is submitted that the petitioner is working as manager in the Punjab National Bank, being posted at Cuttack, and is residing in a rented house at CDA Sector 7. Stop. She also has a minor son. Stop. It is further submitted that it is difficult on her part to attend the court at Bhubaneswar on each date of posting of the case. Stop. She therefore and the petitioner is residing, the opposite party is residing in Australia.
No, Australia. He is residing Australia service kartala. Ebe aschanti Bhubaneswar address they file karchanti. In practically he is not living at Bhubaneswar.
So he will be in difficulty. Anyway,
He is serving at Australia, Melbourne.
the real posting of the case. On such grounds, it is prayed that the proceeding may be transferred from Bhubaneswar to Cuttack. Stop.
যেহেতু তাଙ୍କର ঘর ଅଛି ভুবনেশ্বରରେ ସେ address ଦେଇଛନ୍ତି.
After considering the submissions and going through the pleadings of the pleadings, this court finds no reason to direct transfer of the proceeding from Bhubaneswar to Cuttack. More so when facilities for appearing through virtual mode are available at either place for the parties. Stop. Under such circumstances, I am not inclined to entertain this application. Stop.
My lord, I pray.
The transfer application is, however, disposed of, granting liberty to the petitioner to move appropriate application before the judge, family court, bracket 1, Bhubaneswar, seeking permission to appear through virtual mode. Stop. If such application is filed, the same shall be considered, having regard to the fact that the petitioner is a lady residing at Cuttack, is a working lady residing at Cuttack with a minor son. Stop. Further, her personal attendance shall not be insisted upon unless absolutely necessary. Yes.
In each date.
It will not be insisted upon unless it is absolutely necessary. As a sakhi deba to dijibe apan na.
ସାକ୍ଷୀ ଦେବୁ ତ ଯିବ. ସେଟା evidence ଟା
ଅଯଥା ସବୁଦିନ ତ ରହିବାର କୌଣସି ଆବଶ୍ୟକତା ନାହିଁ.
insist କରୁଛନ୍ତି କୋର୍ଟ ନାହାନ୍ତି ଆବଶ୍ୟକ କିଛି. ଠିକ ଅଛି.
ଏଇ order ହେଲା ଆପଣ you are armed with this order, nothing will happen.
Oblige.
Item number 8.
In spite of this, if he insists, then you can always come to the court, come to this court.
My
Yes.
lord.
May I please your lordship, I mean VC, my lord.
Yes,
Urgent sat pedal.
yes, urgent copy.
Your lordship, the wife seeks transfer of the case from Hon'Ble to Rairangpur, your lordship. Already litigations are pending at Rairangpur where the husband is appearing in few cases. And in fact, disclosure assets of liability statement has already been that I have indicated.
You are appearing.
No, I am.
Acha, acha.
He is with me, your lordship.
Yes. So take notice then. Take
My
notice. Issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed within 3 working days. No, by Monday. By Monday. Hala, release this matter on 3rd May. आइए further proceedings in ये कौन लिखा जाएगा in the said petition bracket civil number 21. What is the actual nomenclature of the case?
CP number, my lord.
हवा कथा बोली मु कौन करियो तो है ही नहीं
CP number 21, 24.
आगे किन जानी मु सेटा I will know, I will imagine. What Mr. Sarangi?
No, your lordship may indicate Mr. Naik's.
No. This I cannot consider. Your prayer is to stay some non-existent case. So even if I pass an order, it will be
He may
unenforceable.
be permitted to correct it, your lordship.
Land Council for the petitioner is permitted to correct the lower court case number in the petition and the prayer portion in court. Stop. Further proceedings in CP number
21 or 24.
21 of 2024 pending in the court of Learned Judge Family Court Hon'Ble shall remain stayed till the next date. Correct it now, my lord.
9.
The wife petitioner, my lord, seeking transfer from Bargar family court to Sonpur family court.
Borgo to Sonpur.
My lord.
Why?
Earlier, my lord, your lordship say, seen, my lord. The husband filed a mad case, my lord, 67 of 2022, which was also challenged. During course of pendency of this case, the husband opposite party, my lord, praying here to withdrawal of the case. Thereafter, my lord, this order has been passed. In that order, now it is this is also pending. My lord. Thereafter, again she has filed, the husband has filed, my lord, mad case numbers 114, my lord. That is also pending here. But there is a liberty, my lord, to withdraw that case, my lord.
So he did not withdraw.
Withdraw, my lord. Again, he has filed this case.
Another case.
My lord.
Yeah, 114 of 2020.
My lord, this is the present case. And earlier, my lord, 67 of
Seek any liberty to file a fresh application?
No.
He could have. How do you know? How do you know? This is the order of this court. Now, what is the order passed by the court below permitting withdrawal?
That is paragraph 1 he stated, my lord, in plain itself.
Not in plain. What is that order? You must see the order sheet of that of the family judge passed in the previous case.
My lord.
There could be order 23 rule 1 coming into play.
My lord. He has pleaded, my lord. Kindly have a glance. Paragraph 3 of the MAT case number 114. Earlier, the present petitioner had filed MAT case number 67 of 2022 before this court for dissolution of his marriage with the respondent dated 28 to 2020 on the ground of desertion. This said application was erroneously filed on dated 16/7/2020.
No, because 2 years have elapsed.
My lord.
2 years have elapsed. 2 years have elapsed, so that application becomes maintainable. Earlier, it was not maintainable. That is why he had.
My lord. My lord. That is the ground.
Anyway, Borgodru Sonpur kete bato?
Yes, my lord. The Omen, my lord, belongs to
Sonpur
160 kilometers.
Okay.
Kindly imagine, my lord. 160.
Issue notice. Yeah. To the opposite party by speed post. Fixing a short returnable date. It be filed by Monday. Place this matter on 3rd May. Further proceedings in MAT case number 114 of 2023 pending in the court of Learned Judge Family Court, Bargod, shall remain stayed to the next date.
Obligement.
No 10.
Annual kali password.
Password?
Two password. Another code.
Let him come. Let him come. Password. All right. Let him pass. He's asking for a password.
Again. Se to achchalo mu kare aram kare dite phone dita.
No. Say okay. Let him come.
Item 11.
Let him come.
Item 11, my
Item 11.
password,
Yes.
my lord. Password, my lord.
All right. Password.
Item 13. 50.
This is that matter which I was arguing. Very related question. I have already practically argued just to recapitulate this memory. Also kindly turn to the impugn order at Annexure 10. And for the opinion number 3. Annexure 10.
Where it was argued, contended by you that he having submitted to the jurisdiction of the sub-collector, he cannot take up.
One and the provision also section 7A3 and 7A6.
Yes, yes, yes.
Just to recapitulate and then I'll
Yes,
sum up my argument. Annexure 10 at page 32.
yes.
This is the
By way of an affidavit.
Yes.
page 32.
Page 32.
This is a letter from the director of higher education to the sub-collector come special officer. Let's get it.
Yes.
And I am directed to invite a reference. This is impugned that the director of higher education has been pleased to approve the draft charge level against the Girija Shankar Mahapatra. He is the petitioner. Principal in charge of so and so school. Then the next annexure is also impugned. Annexure 11. This is also a letter from director to the sub-collector. Allegation against the principal in inviting a reference to the subject cited above and directed to request to intimate the name of the senior most teaching staff of so and so college to be appointed as the principal in charge of the said higher secondary school. Then the next one is Annexure 11 capital A, which was incorporated by way of amendment by challenging this, is a memorandum of charge. Let's look at that.
Yes.
This is a memorandum of gross negligence, tampering of biomedical attendance, gross misconduct. Now you must kindly come to the counter filed by opinion number 3, A by 3, annexure A by 3. Two questions was raised before so on behalf of the petitioner. First question is the director has no power and director could not have approved the draft, the allegations. And second is sub-collector has also no power because sub-collector being the president, he has no power. That is what the entire argument, what I have understood. Even also we look to annexure A by 3.
Yes.
Also look to, this is a dated 18/3/2020. In exercise of the power conferred under section 7 capital A3 of the Act, the sub-collector Teluja is appointed as a special officer in respect of Anchalika Higher Secondary School, so and so, to exercise all administrative and financial power of the governing body of the college, junior college under the provision of the Orissa Education Act till reconstitution of the governing body of the said higher secondary school. You also see this has been passed by the director of higher education. Director of higher education is the prescribed authority and exercise power of section 7A3. Now I will also look to page 29. Because these two documents have been placed before lordships. Page 29. Annexure 8. To the writ application.
Yes.
Let's get it. This is the earlier one is 18/3/2020, which is in exercise of the power under section 7 capital A3. And this is under annexure 8 on 8/9/2020 by the government. That was by the director, this is by the government. In exercise the power conferred under the proviso to subsection 6 of section 7 of the Orissa Education Act, pending the constitution of the governing body of the managing committee, government after careful consideration have been pleased to dissolve the governing body of managing committee of all non-government aided higher secondary schools as per junior college of the Orissa coming under the purview of the school and mass education department with the immediate effect, except the higher secondary school where sub-collector additional district master have already been nominated the president of the governing body. Then where the higher secondary school is situated in the district headquarters, the additional district master of the concerned district shall act as the president of the governing body or the managing committee till the governing further order. In case of any district having more than one additional district magistrate, the district magistrate or collector shall nominate one of the additional district magistrate to act as the president of the governing body. Then where the higher secondary school is situated outside the district headquarters, the sub-collector of the subdivision concerned shall act as the president of the governing body. These notifications shall come into immediately with effect when therefore an argument was advanced before lordship. This annexure A by 3, which was in exercise power on section 7A3, was superseded by annexure 8, according to the argument which was advanced by this. Now, just have a glance these two provisions. I had placed before lordship, but again I am placing 7A3. So for 18/3/2020, annexure A by 3 power has been exercised under section 7A3. That's a look to again 7A3. That is at page of your lordship's book at 136. Yes. 7A Get it?
Yes, sir.
Supersession and reconstitution of the managing committee of the governing body. We are not concerned about the supersession because here the governing body has not been superseded. Then you also kindly come to para 3, 7A3. During the period intervening the supersession, or you must be kindly look to that, or expiry of the term of a managing committee or governing body, as the case may be, and its reconstitution, the power and function of the managing committee of the governing body, as the case may be, shall be exercised by such person or person as the prescribed authority may appoint. Now, annexure A by 3, where in exercise the power of section 7A3, after the expiry of the term of the governing body, the director has appointed the sub-collector to manage as a special officer to manage, to exercise the power and function of the managing committee. Then what is the power and function of the managing committee? If you also look to page 673 of this book, 91 rules. 673. That rule is Odisha education, that management.
Yes.
Rule 30. Rule 30. Power and function of the governing body.
Yes.
If you are subject to the provision of the Act and the rules, the governing body shall exercise the power and discharge the function as follows. Let's come to D and E. We are concerned with D. To ensure the appointment of teaching and non-teaching staff, D. Then E. To ensure implementation of the provision of the Act, rules, and instruction issued by the department or the director in the matter of condition of service of staff.
Yes.
Staff relating to the appointment, salary, leave, pension, provident fund, and retirement, and disciplinary action. Just mark it. Disciplinary action. So now, if you also will read 7A subsection 3, which confers power on the special officer after the expiry of the governing body to be appointed, and the power and function of the governing body has to be exercised by the special officer as being appointed by the prescribers. Now you must kindly come to, this is with regard to A by 3. That with regard to the other, that 20, you also look to 7A6. 7 capital A6. You also again look to that page, that power has been exercised here by the government. That is at page 29. Again, you also look to that.
Yes.
In exercise the power conferred on the proviso to subsection 6 of section 7, the governing body dissolved. All the governing body dissolved. Where the term has not expired. In our case, term has expired and sub-collector has been appointed. You also look to section 7(6). I'm reading it again. The prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7 capital A to continue in office till the governing body or the managing committee reconstituted, or appoint any person or person to exercise the power and discharge the function of the governing body or the managing committee during the intervening period. This 7(6), the principal provision must be read with 7A3. Same thing. Proviso. Because here power has been exercised under the proviso of section 7(6). Provided that the state government may reconstitute the governing body or the managing committee as the case may be, notwithstanding that the term of such governing body or the managing committee has not expired, on such reconstitution, the existing managing committee or the governing body as the case may be stand dissolved. Of course, they have dissolved it, they have not reconstituted, but they have exercised the power of section 7(6) subsection the proviso. A much emphasis was given on this comment order at page 29, because argument was advanced that 7A3 has been now the power which has been exercised, that has been superseded by this. That is, I think that is right. Now, so far the power of the director is concerned, I had already shown your lordships that 74 rules, that is at page rule 26. So you have noted that. Yes, at page 970.
970.
970.
No, sir.
Sorry. 9. That is, I'm sorry. That is page 74. Sorry. That is 976.
Yes. The rule starts from 976.
Right, sir. Right.
But the relevant rule is at page, I think,
page.
disciplinary action.
The 26 power. 26 power. That is at page 999. 999.
Yes.
Director powers of revision, notwithstanding anything on clause, notwithstanding anything contained in Rule 22 and 23, director may, on his own motion or otherwise, after calling for the records of the case, reverse any order which is made or is applicable under the rule and may be pass such further order as he deemed fit. Confirm, modify, impose any penalty, remit the case, then pass such further order as it deemed fit. So for the power of the director is concerned. Now in the present case, you'll also kindly have a glance to the entire, because I have already placed before lordships, I did not place the whole thing. Only one or two documents I'll show you lordships. That's why straightway come to page 35. Page 35. Page 35, that is page 35 of the counter, that is counter filed by OP number 3, that is annexure D/3 series.
I said D/3.
Yes, sir. Also turn to D/3, the series, that is dated sub-collector's letter dated 25/6/2020.
Yes.
This letter has been issued to the principal in charge, that means present petitioner, non-maintenance of cash book and use of card or biometric attendance in respect of so and so, inviting a reference to the caption subject and request you to produce the cash book, relevant register relating to maintenance of cash and detail regarding use of card or biometric attendance, because there is allegation of manipulation. Ancholika Higher Secondary School, before the undersigned within a week positively, in order to conduct an inquiry into the negligence in duty of Sri Shankar Mahapatra, principal in charge, and to submit action taken, submit the action taken, report to the Directorate of Higher Education Orissa for information and necessary action. Any deviation in producing documents, so and so, so and so. So, kindly come to the next page, page 36. I think the present
Last time you had placed it.
that's it. No, what I am trying to place, I did not place the other document because series of documents are there. He himself has addressed the letter to the director to make an inquiry and requested the director to do all these things. And the director also himself made the inquiry, and the sub-collector has also has taken up the matter for inquiry, and he himself accepted the authority of the sub-collector and also submitted the document, and you also look to that page 36. That is my
Yes.
right. So page 36, the sub-collect, he accepted and he submitted the cash book and other. Then if you also look to what this is, I have already placed page 37. Before I take your to the judgment, which I'll cite to your
Yes.
page 37. This is the letter now from the petitioner itself. To whom? To the director. And you also look, what is the subject? I must appeal for your direct intervention into my grievance for unlawful action against me. And the request is, that is at page 41. With these words, for core of my heart, I appeal your honor for seeking your direct intervention into the issue. The documents which are produced by the petitioner before the director. Then I did not place other document. Time and again he requested the director. Director himself has made an inquiry to senior officer of the directorate, additional director. They have visited a visit. They have given a report. Then the sub-collector was directed to make an inquiry. Thereafter only the draft charges have been framed and all this. Now this is so far the substance of the power, statutory power available under section 783, which has been exercised. Now, so far the post of my learned friends, client claims to be the principal in charge. Okay, principal in charge, you also know that is not a substantive post. That somebody, there is a vacuum in the principal office, somebody will remain in charge. A judgment of Supreme Court from this honorable court, Pavitra Mohan Das case, you also must have seen also that judgment. One paragraph, if you also will see. One, just if you also come to paragraph 8 of that judgment, towards the bottom, towards the last part. Let's come to towards the last part. Last part, para 8, just above para 9, we would further make it clear. Para 9, above para 9, 6th line from the bottom in para 8. We would further make it clear that a person who has been appointed as headmaster in charge cannot claim any right on the basis of that appointment, even if the same might have been approved by the competent educational authority. The in-charge headmaster is not the same as the headmaster of the school, and merely entitle a person to remain in charge and discharge the duty of the headmaster. In this view of the matter, where the appointment itself has been to the post of headmaster,
Sir, can you just wait for a moment?
No. Math. I'm just repeating.
I remember something I had to tell him in the morning, I forgot.
Oh, yes.
Yes, sir. So not to remain in charge and discharge the duties of headmaster.
The in-charge and as such appointment has been approved. Obviously, said appointment cannot claim to be continued as the headmaster or to be entitled to get the scale. The special bench in the interim judgment has corrected. This is a case also. Remember, 5 judges bench. This is the only 5 judges bench so far the headmaster in charge.
Yes, sir.
That matter was there. Then this is so far the headmaster in charge. He has no right. The principal in charge, the headmaster in charge, more or less in the same. Because a person, there is a substantive post of principal, because the post of principal has not been filled up, somebody has remained in charge of principal. Here is a case, here is also a case that admittedly the petitioner was not the senior most. I think Mr. Swine's client, yes, Mr. Swine's client is the senior most. His case was that at the time when the vacancy was caused for the post of principal, because there was a circular, there is a executive instruction, if somebody refused to accept the principalship, then he cannot claim further. But that very circular has been withdrawn subsequently. My non-friend's client argument was that is during the pendency of the writ application. It's not a question of pendency. Letter was issued by the government or the director or additional secretary, and that has been withdrawn. But a right of a person to be considered as a senior most person cannot be wiped out. Merely because at that time, at the relevant time, he has some problem, he refused it. So that is so far as the post of principal in charge. Here, what has happened now? He made allegation, teachers made allegation, others have made the allegation. Ultimately, on inquiry, it is found that there is some manipulation of records and manipulation of that biometric and other things and misappropriation. All that, these are all allegations. I can't say that is the conclusive one. Even if my non-friends doing his office of the charge, which have been prepared for the purpose of inquiry. Disciplinary proceeding. He has a right to file written state of defense as a lecturer. That is always permissible. Now, this is so far as the background is concerned. There is only one judgment I show that if a person, that is very well-known principle, just a judgment I can give to your lordships. If a person has assumed the authority of a particular authority and he participated and accepted his jurisdiction, subsequently because the order has passed against him, he cannot challenge it. Stop it. That is also one judgment that is there. I'll give a note and I'll give the page. This is reported in 2023 Supreme Court, 2769. Para 43. Paragraph 43 at page 11.
Yes, I got it.
The principle of accuracy has been explained in the Black's Dictionary as persons' practice or passive acceptance or implied consent to an act. It has been described as a principle of equity, which must be made applicable in case where the order has been passed and complied with without raising any objection. Acquiescence is followed by estoppel. A constitutional bench of the Supreme Court in Panalal Bhajilal versus Union of India, AR 57 Supreme Court, 6 decades ago, had an occasion to explain the scope of estoppel. It says that once his order is passed against a person and he submits to the jurisdiction of the said order without raising any objection or complies with it, he cannot be permitted to challenge the said order subsequently when he could not succeed. The conduct of the person in complying with the order submitting the jurisdiction of the order of the court by participation, this entitles him to any relief before the court. This is that judgment. And the other thing regarding that same judgment I have also prepared. I'll go to lordship. I will take your lordship's time. This is the principle. Then my whole submission is that so far as allegations which have been made against the petitioners, that will be inquired into, And at this stage, the petitioner has no right to come to this court and to on the ground that neither the director has jurisdiction nor the sub-collector has jurisdiction. So therefore, this is my entire. I'll give a note, short note of submission with date checks.
Well, your lordship may kindly take up the connected matter, that is WPC number 633 of 2022. Yes. You have filed it? Yes, I have filed it. Why? Well, I have filed it since I am the senior most lecturer of that college. So therefore, I have filed this writ petition to approve me as principal in charge of that college, because serious allegations have been made against the private opposite party. And since he filed a writ petition and obtained an interim order, and because of the interim order, the process could not be completed. Although the director and the special officer directed that the senior most lecturer, his name should be recommended to the director and he should be approved as principal in charge. My lord, for a moment, your lordship may kindly see the approval order. Annexure 3 at page 21. I will not bother your lordship by taking your lordship's time, because my learned senior friend has already argued. Annexure 3 at page 21. My name finds place at serial number 6, Harivarpati. My lord got it. My date of appointment, date of joining is 26/11/1993. My date of birth is 4/6/1970. Where do you get it? Oh, yes, yes. Serial number 6. Yes, yes, yes. Harivarpati. And so far as the opposite party number 4 is concerned, who is the petitioner in the other case.
But how is the date of birth relevant? So you have joined earlier.
Yes, I have joined earlier. So both in respect of date of birth as well as the date of joining, I am senior to him. Your lordship may kindly see serial number 4.
Yes, I have seen.
Girija Shankar Mahapatra, he joined on 30/5/1994. The only bottleneck against me is when the college was notified to receive block grant from the state government in accordance with the granting aid order of 2008, and my name was about to be recommended for appointment as principal in charge, but because of my personal difficulties, I gave an undertaking. In strict sense, that is not an undertaking. I sent a letter on 18/7/2011, that is at Annexure 5.
Yes.
That for the time being, I am not interested to hold the post of principal in charge. I am just placing that letter.
You proposed the name of the referent.
No, I have proposed. Your lordship may kindly see that.
Yes.
Tenor of that letter. I, Harivarpati, lecturer in botany, Anchalik Vigyan Mahavidyalaya, Sirivida, Keonjhar, date of birth such and such and date of joining such and such. As per the government approval letter and other college records, I am the senior most lecturer of this college and eligible to act as the principal of this college. But I have some personal unavoidable difficulties and unwilling to act as the principal of the college for the time being. You will kindly mark it, the time being. I propose Mr. Girija Shankar Mahapatra, lecturer in chemistry of this college, to act as the principal of the college. Thereafter, your lordship may kindly come to Annexure 7 at page 29. The appointment of the opposite party number 5, who is the petitioner in the other case, his appointment was approved as principal in charge cum secretary. So this is the only bottleneck against me. My learned friend has filed a counter. In the counter, he has annexed a government circular. Your lordship may kindly see the counter filed by the opposite party number 4. That government circular, whether it is applicable or not.
It is 23/3/2015.
23/3/2015.
Yes.
15. Your lordship may kindly see, in respect of this circular was issued on 23/3/2015, and my undertaking or whatever, well, that was made in the year 2011. That was made on 15/7/2011. By then, this circular was not there. Which one? Annexure 5? Annexure 5. Annexure 5 is the undertaking. Undertaking. It was in on 15/7/2011. Yes. So what is this resolution? The resolution was made on 23/3/2015. So by then, this resolution was not there. So it has no retrospective effect. That is my first submission before your lordships. My second submission before your lordships is this resolution dated 23/3/2015. This does not apply to 662 category of colleges. But admittedly, this college was notified as per the grantinate order of 2008. This is neither a category 1 college nor category 2 college. Category 1 college means the colleges which have received grantinate prior to 1694, and category 2 college means the colleges which have received grantinate with effect from 16/1994. So therefore, in the first paragraph, in the second paragraph, it has been clearly mentioned that this circular is applicable, this resolution is applicable for 488 category of colleges. Where are you reading from? Second paragraph of that. Yes, I got it. There are no regular post of principals in non-government aided colleges of 488 category colleges, 255 category 1 and 233 category 2 colleges as defined under para 4 of grantinate order in the state. In the state at present, the post of principal is managed on ad hoc arrangement. That is, the senior most teaching faculty of the college is appointed as principal in charge, who acts as drawing and disbursing officer of the college concerned. In the absence of regular principal, quality of education and day-to-day administration of the colleges have been affected. Then your lordship may kindly come to the relevant paragraph. Page 7. Para 5. Yes. This is the offending clause according to them. A person appointed as principal in case not willing to join the post shall give the same in writing through the principal so that his/her claim for holding the post in future shall not be taken into consideration. So my submission before your lordships is, at the cost of repetition, first of all, this resolution is not applicable to me because when I submitted an undertaking, such a resolution was not there. And at best, this resolution is prospective in nature. It has no retrospective operation. Number 2, this applies to 488 category of colleges, that is category 1 and category 2, and not in respect of category 3 colleges like this. And my next submission before your lordships is, since I have not say your college is category 3. Category 3. As per grantinate order 2008. Because it got granted in 2009. Let me just understand, sir. Yes. Your lordship, page 2008 order. Kitne sara page page that is article. Because that is in 1994 also, that category thing is very cumbersome. Yes, it's 90, very cumbersome. I had a tough time dealing with it in that case where I think the senior counsel was arguing. It went against 2, but I had a very tough time, sir. I broke my head. Understanding is category 1 means the colleges which have received grantinate prior to 1694. That is understood. Prior to commencement of the Amendment Act of 94. Category 2 means the colleges which have got grantinate from 16/1994. And category 3 means the colleges which have been eligible or got granted after 16/1994. No, but it is not that easily worded. It is very difficult to understand. Very difficult to understand. Your lordship may kindly come to me. That's why you find it easy to understand, but for persons like us, it's a page 443. And this is granted order of 2008. Yes. And your lordship may kindly see the notification. Annexure 1 of my writ petition. Annexure 1, yes. The college was notified at 27 June 2011 as per granted order of 2008. My lord got it? Yes. Annexure 1. So this is a category 3 college. So this resolution is not applicable. Well, and my next submission before your lordships is, so far as my so-called undertaking is concerned, that is not permanent in nature for the time being. The language used is for the time being. And thereafter, I have expressed my willingness to act as principal. That application is also there. That is Annexure 8 at page 30. Yes. My lord, may kindly come to Annexure 8 at page 30. I, Sri Harihar Pati, lecturer in botany, ABH School, Serigida, District of Keonjhar, humbly beg to draw your kind notice that I was not interested to hold the post of principal during the post-approval room to physical problem and for the treatment of my bedridden father. At present, I am free from all hurdle of my family life, and all other staff of our college are requesting me to take the charge of principal post, and other things are there. And this representation was made on 5/1/2020 when these allegations and counter allegations were made, and and thereafter, your lordship may kindly see, so far as that resolution is concerned, that resolution was withdrawn. My lord may kindly see my additional affidavit. Yes, additional affidavit dated 1/1/2023, Annexure 19. My lord, got it? Yes, yes. On careful consideration and approval of the competent authority of government resolution number such and such dated 23/3/2015, issued by the Higher Education Department and published in Odisha Gazette number such and such, on the subject of posting of principal in non-government aided colleges in the state, is hereby declared to be withdrawn. So that controversial resolution dated 24/3/2015 was withdrawn. This was withdrawn on 24/2022. Now, my lord, so therefore, the bottleneck or hurdles which was there, that is gone. That is my first submission before your lordship is. Then my alternative submission before your lordship is, in the first case, the petitioner, who is the opposite party number 4 in the present case, my lord, what is his prayer? In essence, his prayer is that unless the disciplinary proceeding is completed, he cannot be dislodged from the post of principal in charge. This is number one. Number two, the sub-collector who has been appointed as special officer in accordance with section 7A(3) of the Orissa Education Act, he has no jurisdiction or authority to initiate any disciplinary proceeding or dislodge him from the post of principal in charge. These are the 2 points which he has advanced. My lord, my learned friend has already argued before your lordships that so far as the post of principal is concerned, that is not a substantive post. That is a stopgap arrangement. When regular principal is not there, that is a stopgap arrangement. So even if it is approved, appointment of principal and in charge is approved, that does not create a right. That does not create a right in his favor. But I have brought a decision of the Honorable Apex Court. Pavitra Mohan Das case is concerned, my learned friend has shown to your lordships. Another case your lordship may kindly see. This is reported in AR 1997 Supreme Court, page 251. Sridham Chandra Ghosh versus State of Assam and others. My lord may kindly see, exactly situation is exactly same. Para 3 and 4. My lord, got it. Rule 9 prescribes the qualifications and the procedure for appointment by promotion to the post of headmaster out of the select list of vice principal, assistant headmaster and postgraduate teachers having 15 years continuous teaching experience in the service. Admittedly, there is no order of appointment made to the petitioner. As having been seen from the record, it is only a stopgap arrangement made of the petitioner to officiate as headmaster
till the regular incumbent assumes office as headmaster. Therefore, he does not have any right to the post to hang on after the regular incumbent has been transferred to the post. Then paragraph 4. It is then contended that ousting of the petitioner from the post amounts to punishment. The procedure prescribed under the Assam Civil Service Discipline and Appeal Rules has not been applied. It amounts to demotion of the petitioner from the service of the headmaster to the post of assistant graduate teacher. Therefore, the High Court has overlooked the statutory provision. The learned counsel is wholly misconceived in his conception of the law. The Assam Civil Service Discipline and Appeal Rules apply only in a case where disciplinary action is sought to be taken against a government servant in accordance with the principles. In this case, since the petitioner was officiating and regular incumbent has to assume the office and the petitioner has to hand over the charge to the new regular incumbent, it is neither demotion nor a punishment. Now, Your Lordship may kindly see Pavitra Mohan Das. I will not cite because my learned friend has cited. My lord, what is the punishment? Well, a discipline. Admittedly, a disciplinary proceeding has been initiated against him. So far as dislodging from the post of principal in charge, that is not a punishment within the meaning of Rule 20 of the 1974 rules. My lord, may kindly see Rule 20 of the 1974 rules, whether it amounts to reversion or demotion. Because admittedly, he is an employee of an aided educational institution. 74 rules, service condition rules is applicable. My lord, may kindly see Rule 20, page 992. Nature of penalties. Yes. The following 21. The following penalties may, for good and sufficient reasons, and as hereinafter provided, be imposed on an employee of an aided educational institution, namely A, fine, B, censure, C, withholding of increments or promotion, D, recovery from pay of whole or part of any pecuniary loss caused to the institution for negligence or breach of order, E, suspension, F, reduction to a lower service grade or post or to a lower scale of pay or to a lower stage in the scale of pay, G, compulsory retirement, H, removal from service, which shall not be a disqualification for future employment, and I, dismissal from service, which shall ordinarily be a disqualification for future employment. So my submission before your lordships is, relying upon Rule 20 of the 1974 rules, if one is dislodged from the post of principal in charge, because that is not his substantive post is lecturer. So in the event any punishment is imposed upon him, that will be any punishment as provided under Rule 20 of the 1974 rules. So therefore, my submission before your lordships is, since no right accrues in his favor, since he is holding the post of principal in charge, which is a stopgap arrangement, so he can also be dislodged from the post of principal in charge if serious allegations are there or because of the eventuality. My lord, so far as the disciplinary proceeding is concerned, because he has also challenged the disciplinary proceeding in the first writ. My lord, I am citing one judgment of the Honorable Apex Court. My lord, ordinarily your lordships will not like to interfere with the disciplinary proceeding unless it is without jurisdiction or the authority who has passed that order has no power to initiate disciplinary proceeding.
The basic plank of his argument is that it is without jurisdiction.
Without jurisdiction. I will answer that. Before that, your lordship may kindly see this.
He has not taken me to the facts of the.
I think he is not the party in that case.
Anyway, this is point of law I am conversing.
Letter bar also.
Already sent that. Anant Kutkar.
Give a composite reply, whatever he says. Give a composite reply.
My lord, may kindly see this decision.
Anant Kulkarni, yes.
Para 7 and 8.
But I think this is settled position of law.
This is settled position of law. This is
Normally, this court And we are in subsidiary.
Yes, yes,
So it will not
yes.
interfere unless it is.
Then, my lord, so far as the jurisdiction of the sub-collector is
I think
concerned.
that he has argued.
Yes.
Argued at length.
Yes, my lord. I will also argue on that. My learned friend has already shown to your lordship section 7A3.
Never fix it.
देखो
7A3 that you are referring to.
7A3. Your lordship may kindly see 7A3.
I think the senior counsel has already placed it.
Yes. My submission before your lordship is, I'm not placing it.
No, I have understood what he has said as between annexure A/3 and annexure 8.
Yes.
So according to the senior counsel, this does not supersede the other. They operate on different
Different.
That point is taken.
My submission before your lordship is, so far as section 7A3 is concerned, that is a special provision where the term of the managing committee is over or the managing committee is superseded.
Authority steps in.
Authority may appoint a special officer who will be in charge of the management. And my learned friend has shown rule 30, what are the powers of the management? He will exercise that power. But so far as the proviso to
Subsection 6.
Subsection 6 of rule 7.
Section 7.
Section 6. Section 7, subsection 6. My submission before your lordship is, the notification was issued by taking recourse to that provision. That notification was recently quashed in one of the case in Bajanti. My lord, may kindly see that judgment. My learned friend has cited that judgment. In that case, 7 and 3 was never taken note of. My lord, may kindly come. Paragraph 7.2 and paragraph 7.3. Because a perimetry circular was also issued in respect of degree colleges. You will also kindly see that. This is a junior college.
7.2, you are showing me 7.2 paragraph.
7.2, 7.3 and 7.4. A circulator thila degree college pe. You will also kindly see that.
Same.
Junior college ta dekhiye.
Subsection 6 of proviso.
In exercise of powers conferred under proviso to subsection 6 of section 7 of the Orissa Education Act 69, pending reconstitution of the governing bodies or the managing committees, government after careful consideration have been pleased to dissolve the governing bodies or managing committees of all non-government aided degree colleges of Odisha coming under the purview of Higher Education Department with immediate effect, except the autonomous colleges and the colleges established by minority communities. Where the college is situated at the district headquarters, the additional district magistrate of the concerned district shall act as president of the governing body or the managing committee until further orders. In case of any district having more than one additional district magistrate, the district magistrate and collector shall nominate one additional district magistrate to act as president of the governing body or the managing committee. When the college is situated outside district headquarters, the sub-collector of the subdivision concerned shall act as president of the governing body or the managing committee till further orders. Same perimetry circular was issued in respect of junior college. My lord has seen that. Junior college ta do.
Page 29 is it?
You will also kindly see that. Same perimetry.
That I've seen.
Yes.
Yes.
So both the circulars were issued in exercise of power under subsection 6 of section 7 of the Orissa Education Act. Provide you to subsection 6 of section 7 of the Orissa Education Act. Now your lordship may kindly see the judgment.
99.
Yes, please.
Before that, your lordship may kindly come to para 7.1. As found from the record, the governing body of the college so constituted on 13/12/2019
was dissolved in notification issued by the government on 24/1/2020. That circular. Contents of the notification dated 24/1/2020 is reproduced hereunder. In exercise of powers conferred. Yes. That has been quoted, then your lordship may kindly come to para 7.2. As found from the said notification, on such dissolution of the governing body and managing committee of aided educational institutions functioning in the state, additional district magistrate of the concerned district was permitted to act as the president of the governing body or the managing committee until further orders. This court, after going through the provisions contained under section 3H of the act, read with section 7.3 and rules 21, 25 and 29 of 1991 rules, finds that it is the governing body, a body of individuals who is only competent to take disciplinary action against its employees. But in view of the decision rendered in the case of Sri Satya Sai Seva organization, we still govern the field. Once a governing body is dissolved, there exists no governing body for which the president can be nominated. But in view of the notification issued by the government on 24/1/2020, opposite party number 3 in his capacity as additional district magistrate was allowed to discharge the duties of the president of the governing body. Since neither in the act nor under the rules, president of the governing body is permitted to take any disciplinary action, which only can be taken by a duly approved governing body, it is the view of this court that the direction issued by the government in the impugned order dated 22/10/2021 under Annexure 8, permitting opposite party number 3 in his capacity as president of the governing body to initiate a disciplinary proceeding against the petitioner is not sustainable in the eye of law. The direction so issued on 22/10/2021 under Annexure B is hereby quashed. So my submission before lordship is, there is a distinction between section 7A3 and the proviso to subsection 6 of section 7. And both the circulars were issued by taking recourse to section 7C, that proviso to section 7(6) of the Orissa Education Act. And by virtue of those two government circulars, what has happened? The sub-collector in case of rural areas, he has been empowered to act as president of the governing body. So my learned friend's contention that that circular supersedes the other one, by virtue of which the sub-collector was appointed as special officer as per section 7A3 of the Orissa Education Act, that is not legally correct. And section 7A3 not been dealt with in any of the cases. So far as Satya Sai Seva organization case is concerned, because basing upon that Satya Sai Seva organization case, this judgment has been delivered. Your lordship may kindly see Satya Sai Seva organization case. Satya Sai is here.
Yes, your lordship may kindly see. 2008 to OLR page 432. What is the ratio in that case?
Satya Sai, it says, yes. I have it. Paragraph?
Para 9 and 10.
Yes.
Rule 25 of 91 rules, after its amendment in 2001, reads as follows. 25(1). Notwithstanding anything contained in these rules, as soon as the college becomes an aided college, the governing body of the college shall be reconstituted in the following manner. 1. A person interested in the field of education.
I get it. Let us not read that.
Yes. So in that case, what has happened? The sub-collector was nominated as the president of the governing body. There was no full-fledged governing body. Because as per the 1991 rules, for a moment, your lordship may kindly see the 1991 rules. What are they? Rule 21. Rule, ethre the degree college rules tie 25. The same parameter provision achi junior college mein. Degree tabar rule.
Rule, sorry. Degree college. Higher secondary.
656.
Six 681. Your Lordship may kindly see Rule 25, because that has been referred to in that Satyasai organization case. Governing body of Aided College. Notwithstanding anything contained.
Same thing that has been quoted, we need not read it.
That has been quoted.
Yes.
So, in that case, only nomination was, sub-collector was nominated as the president of the governing body after the governing body was dissolved. And thereafter, the governing body is to be met full-fledgedly as per Rule 25 of the 1991 rules. Full-fledged governing body was not met or approved. Only sub-collector was appointed as nominated as the president of the governing body. So, interpreting Rule 25 of the 1991 rules, their lordships held that simply because the sub-collector has been nominated as the president of the governing body, he cannot exercise the powers of the governing body because there is no full-fledged governing body. So far as Section 7A3 is concerned, it is a special provision where the term of the governing body is over or the governing body has been superseded. A special officer has been appointed who will assume the powers of the management. So there is a distinction.
Anyway, well, I get a point.
So my submission before your lordships is, so this order clearly shows that by taking recourse to Section 7A3, the sub-collector has been appointed as special officer who is in charge of the management at the relevant time. That order has not yet been superseded. So simply because the subsequent circular came in accordance with that proviso and automatically that circular or the order passed by the state government, order passed by the director appointing the sub-collector as special officer is superseded, that is not legally correct. So the sub-collector who has initiated the disciplinary proceeding against the opposite party number 4 and who has sent the letter to the director to appoint the senior most lecturer as principal in charge of that college, that will never be without jurisdiction. This is my point.
Yes, Mr. Das. State. Yes.
After hearing the government counsels on the education matter, my role will be limited, my lord. But in this case, my lord.
No, here, before you go on, let me just point out one thing. What Mr. Swami has done is he has tried to distinguish the ratio in Satyasai. Satyasai says that this sub-collector was appointed as a president, but he cannot act as a disciplinary authority. Because he cannot be treated as the governing body. Okay, then?
But my limited submission will be, my lord. The ratio decided in those cases, my lord, that will have no application in this case.
Yes.
My first point, my lord, if your lordship will come to the prayer, consolidated writ petition, my lord, that's page number 14, my lord.
Yes, prayer.
There is a prayer-
10, 11 and 11A.
Yes, ma'am. There is a prayer to quash 10, 11 and 11A. My lord, limiting only these prayers, my lord. My first submission will be without any proper cause of action, even to file a writ petition. The writ petition has been filed.
Yes.
Now, what is Annexure 10, my lord? Annexure 10 is nothing but, my lord, it is a prayer number 32.
Approval of draft charges.
Yes, ma'am. So, the approval of that draft charge to take further action is not a definite cause of action. By which, my lord, a person can say that, my lord, I have been aggrieved.
Yes.
So, my lord, on that score, now, my lord, Annexure 10 is with respect to approval of the charge, draft charge. Now, Annexure 11, I think, my lord, it is completely separate from that one because this letter has been issued on the same day. A writ petition has been filed. How one is consequential to another without saying anything, my lord. This is with respect to recommending a person to remain in charge of principal in charge.
Yes.
So, my lord, although, my lord, the letter has been issued on the same day, whether these two are correlated with each other, my lord, there is no averment. Now, my lord, coming to the point, Annexure 10. Now, another 1 million, 11A has been inserted. What is that, my lord? Let us see that, my lord. That is the draft charge. Now, posing a question to myself, my lord. If a junior engineer, I'm just making an example, giving an example. If a junior engineer whose disciplinary authority is director of the government now, he is working under the collector, Koraput. Then in that case, my lord, for some kind of his delinquency, it is the duty of the collector under whom he is actually working to intimate to the disciplinary authority that these are the delinquency he has committed and accordingly appropriate action may be taken. And for that reason, he has to submit. The person who is actually making such allegation, he has to submit a draft charge. But the final authority has to be exercised by the disciplinary authority. In this case, my lord, the sub-collector has exercised his power, being the authority who has been appointed, and his appointment is not under sub judice before this honorable court. That Annexure 11A has been issued by him after conducting an inquiry, fact-finding inquiry, preparing a draft charge for its approval.
Yes.
I will differ here, my lord, that whether he has exercised this power as the disciplinary authority in this case, as it has been submitted before lordship.
Yes.
Now, at this stage, my lord, I may take a lordship to section 20, so rule 20, my lord, or that rule 1974.
Yes.
My lord, rule 20 is the nature of penalties. It covers all kind of penalties, my lord. Then 21, it defines the disciplinary authority. The first sentence says, the director may impose any of the penalties specified in rule 20 on any employee. So, my lord, I may say, my lord, that it is the director who is the disciplinary authority to impose and having the competency to impose any kind of penalty. Now, with the second one, my lord, that is the provision. Podivi, sir. Podivi na. Provided that the director shall not initiate any disciplinary proceeding unless the managing committee or the governing body, as the case may be, refuses or neglect to take disciplinary action against any employee. Now, my lord, coming here, in this case, my lord, I am taking a lordship to the amendment in para number 6 of the writ petition. Para number 7, my lord. that it is only submitted that it is the governing body who is the competent to proceed against the employees of the alleged offence. Here in this case, there was no allegation whatsoever made against the petitioner by the governing body because there is no governing body in the eye of law. So that in a case where the governing body is not in picture, madam, a person has been appointed to act as the president and he submitted a draft charge. Director approved the draft charge. The definite charge sheet, memorandum of charges, has not yet been issued to the petitioner. So, my lord, my submission, my lord, this writ is not maintainable.
Yes.
Now, my lord, this coming to the subsequent point, my lord, that is 11. That is Annexure 11, my lord. Annexure 11 says that, my lord, there is a instruction to the competent authority to recommend a name. My lord, the manner in which this action has been taken, the same manner, it was also followed at the time of deciding to keep the petitioner as the principal in charge at Annexure 4, my lord. On the recommendation of the sub-collector Keunjhar, President Governing Body of Anchalik Mahavidyalaya Sirigida, the name of Sri Girija Shankar Mahapatra, lecturer in chemistry, is hereby approved as the principal in charge. That was done in the year 2011. So here one instruction has been issued to the sub-collector to recommend the name. My submission was that is not a cause of action for which, my lord, a writ is maintained. And so far the legal provisions and other things, my lord, I concede, my lord, I cannot argue more in comparison to the senior advocates what I have already.
Yes.
Before Mr. Das starts, only some clarification because I don't have any right also to give a reply to Mr. Das. The two judgment before Lordship is one is Satyasai, the other one is that Baijanti. Satyasai is a case, look to Rule 25. The president, nominate to be nominated. A president once nominated, that cannot be said to be a complete governing body. So therefore, only after the constitution of the complete governing body, the sub-collector being the president, he has no right to take any initiative. Here is a case where Section 783, not as a sub-collector, but in the exercise, the power has been appointed as a special officer. Therefore, that judgment, so far that judgment is concerned, how it is connected to this case also. So that Baijanti case is also concerned. That also I was a sincere in the council there. Baijanti case also, that paragraph, which my friend also referred to, that paragraph 778. You will also will see that on the same ground, looking to Section 786, Section 76, that proviso, that so far the degree college is concerned, the same the coordinate bench has said that it has no jurisdiction to like that. So here is a case, even without declaring to be without jurisdiction or something like that, your worship will simply say that power has been exercised in Section 783, read with Section 76 principal provisions after the expiry of the term before the reconstitutions. Such a power is concerned. And so far proviso is concerned, here the government has exercised such a power to terminate or dissolve all the governing body. So 7, you also understood already, but you also already got to our point. 7.6 principal provision, read with 7.3. Certainly, the sub-collector has every power to discharge the duty of governing body, as has been assigned in Rule 3030 of the 1991 rules. That's right. I did not explain it.
Yes, Mr. Das. Yes, please. Yes, please. You have already made your arguments, only to just a brief reply.
This case, my lord, 3 orders. Initially, I filed the case when 2 orders were made available to me, Annexure 10 and 11. Annexure 10 is a document, a letter issued by the Director, Higher Secondary Education on 22/10/2020, directing the sub-collector, addressed to the sub-collector by approving the draft charges level against the Girija Shankar, the principal in charge of this college. There is some draft charge prepared by the sub collector, send it to the director for approval, and the director has approved it and directed him to draw the proceeding. This is a letter of 22/10/2020. This date is important. In the very next letter on 6/11, consequence to this, because there is allegation, can you see? Because all of them, what they have stated, and Mr. Patnaik in the last also stated, because it is the argument of Mr. Rautra as well as Mr. Patnaik, is this is a premature petition. No action taken against him. So he cannot come. With this annexure 10 and 11. Because 10 is an action you take against him. Draft charge I have approved. Now we proceed against him. Now, on 6/11/2020, the subject may kindly listen, page 33. Allegation against the principal and Ancholika so and so in the district of Keonjhar. Sir, inviting reference to the subject cited above, I am requested to intimate the name of the senior most teaching staff of Ancholika Sirigir, Telkui, to be appointed as principal of the higher secondary school. Because some allegation against me, that is the reason for which they want to proceed against me, and now they want to appoint somebody else. So it is not a case as that judgment of Mr. Swain, that Assam case. That case is quite, he has read out to my lord, and as I have understood, that is a case simply a person was there as a principal in charge or headmaster in charge in that case. Another person was transferred. See, he says, no, I will not hand over. There this says, I have been removed from the post of headmaster to assistant teacher, that is a reversion, so I will not hand over. The court has said no. No proceeding, nothing is against you. Original incumbent now come, you have to make room for him. So it is not a punishment, nothing else. You are coming back to your own position. It is not a case of this nature. In the present case, my removal from the post of principal is on basis of some allegation. And allegation is yet to be proved. Unless and until the allegations are proved against a person, if action is taken prior to that, then they amount to punishment. Even whether it is a temporary post or a permanent post, ad hoc post, in charge, whatever it is. If you are removing me from that post with a stigma or with an allegation, you will not find out that yes, I am guilty of the charges. With this, you cannot push me out from the post. That is my submission. That is why I came. So it is not a premature petition. Because only basis of some allegation, you cannot throw me out. It is not the case also. It is not the case. Because other case, Mr. Swain's case, because he is the senior most person. Once he has given a undertaking that no, I don't want to hold this post time being because I have some problem. Now he is coming back that now my problem is over. Now I want to come back to the post. So had it been a case also now, yes, the senior most person is willing to take over the charge. You are not the senior most person, you will take the post. So there is no allegation. Had it been a case of this nature also, I understood, yes, that judgment of Assam case also may help to this case. But it is not a case of that nature, as it understood from the order itself. What I am challenging here. Since this is with the allegation, a stigma, before it is worked out that yes, whether I am guilty or not. Now you are throwing me out. That is the cause of action for me to come before this court. And on this exact point, my lord have decided in one case that Satyajit Rai Chaudhary, I will give you the note. That is my lord's judgment. The same thing, some allegation, financial irregularity, all these things. You are directed to remove from that post. I came before this court. This, my lord's judgment is no, you cannot. You prove it, and then direction was given. You proceed against him, found him guilty. Thereafter, you throw him out. But with the allegation, you cannot throw me out. That is the judgment of this honorable court, this particular bench, and I with the council. So with this case is quite maintainable for this honorable court with these two orders. Now, this annexure 10, what does it say? Annexure, the first order of 22/10/2020, the director has approved the draft charge level against the petitioner, stated to have been prepared by the sub-collector. It was approved. My first response submission to this honorable court, there is no concept of draft charge in a proceeding of an employee of an
That
entity.
you have already argued. That on the first day itself, you have already argued at length.
Well, no, I have not argued length. I never argued length like that. I argued.
Oh, so I take back the word. By length, I am not actually referring to any particular time period. I said that you have argued.
Yes, because now this is because once I have come to the next.
I don't understand the meaning. You are saying that you never argued at length. It is not an insinuation.
Well,
It is not any adverse comment made by the court. Why are you saying it like that?
why repeating if it will be taken as a repetition also, but to bring to my points to give a reply to them, I have to say all these things.
You may say, but I am just pointing it out to you that you have already argued.
Yes,
You have already argued.
yes. What happened? Well, this is a approval order by the director to a draft charge. And the draft charge I have brought it by because that was not available to me. Only from the counter affidavit I got it. I got the amendment, and amendment was allowed, and that is annexure 11A. So now it is an access to before going to an 11A. I am just coming to this first. He approved a draft charge. Now my respectful submission is therefore proceeding against an aided institution employee is to be drawn if it is a major penalty proceeding. It is Rule 22. Rule 22 can have a glance. Of 74 rules, my lord. Page 996.
The detail has been given.
No, yes, only two tackle. 22.2. 22.2.
Yes.
My lord. The disciplinary authority shall frame definite charges on the basis of the allegation on which the inquiry is to be held, and so on, so on, so on. My emphasis is to the word there shall be a definite charge to be framed by the disciplinary authority. No draft charge, no concept of draft charge. And now I have read out of the last other occasion in the first submission that under Rule 22, there is no requirement of the statute that a charge even, if it is a draft charge or the regular charge, it is to get the approval of the director. There is no first concept. Only the director's power is under 22.30. After the proceeding is completed, the records have to be submitted to the director to get an advice. Only at that stage, when after inquiry, everything is over. Line 13, 22.13. So 12 and 13 the disciplinary authority under sub-rule 2 of Rule 21 shall forward the records of the inquiry together with a copy of the order passed by sub-rule 9, 10, 11 to the director for his advice. On receipt of the advice of the director, the disciplinary authority under sub-rule 2, 21 shall consider the advice and determine the penalty, if any, to be imposed on the employee and pass appropriate order on the case. The disciplinary authority shall communicate the order. So that stage of approval is only contemplated in this proceeding. The rule is at 13. That is, everything is over. So charge is to be framed, definite charge is to be framed by the disciplinary authority. It is to serve on the delinquent employee, a teacher or staff, and process is to be completed. Thereafter, the records have to be submitted to the director. So there is no occasion for the director to give a seal to the approval or to the charges. Moreover, it is a draft charge. So my responsible submission is to ascertain at this stage is this order, because my entire allegation is jurisdiction, both all the authorities. So now the director cannot give a seal to any draft charge first. He should have objected to it. If he would have seen the law, he would have objected. No, it is I have no authority to pass such an order. First. The second is, if it is a draft charge, I should not accept. You should frame definite charges. If might have been, there is a charge, but if you are styling it as draft charge, it has to be corrected accordingly. That advice would have been given. But instead of that, he has accepted that, approved it, and not sending him back to the sub-collector to proceed against him. Now, my lord, time come to the charge. 11A. Page 34. That is another approval. 11A. Kindly mark this letter 4830 dated 25/8/2020. I'll mark the date. Here he says, inviting reference to the letter subject cited above, I am to say that irregularity committed by Girija Shankar so and so in the district review. Accordingly, draft charge has been prepared against so and so. This is the draft charge sent to him, and with reference to this, he has approved it. So now, kindly take note of the date. 25/8/2020. The director is framing this charge. Now, kindly turn to is. Yes. But the counter filed by the opposite part number 4 in this case. He has filed all these documents which would not be available to me. I kindly come to page 67 of that counter of the opinion number 4.
Yes,
Page 67.
that he has already placed it.
No, this is not placed. This is page 67, the office of the sub-collector Kehuja.
Page 67.
Yes, of the counter of the opinion number 4.
And it's an E/4.
এটা নম্বর भी কিছু করনাছে মানে র্যান্ডম সে সিরিজ করে দিয়েছেন it will be n/4 series যা মতে কপি দিয়েছেন
10/4, yes.
well kindly come to first told it plus 67 then after I will come to n/4 this thing I have not shown I have not done 67
Yes.
kindly take note of
Yes.
this is kindly take first the date the draft charge was submitted on me
Yes.
issued, not submitted, but it was issued on 25/8/2020. Now, this is a letter of the 25/8/2020 of the same sub-collector. What does it say? In pursuance to, subject is assumption of charge of the special officer. He assumed the charge. Kindly see.
Yes, yes.
In pursuance to office order number so and so dated 18/3/2020 of the Directorate Higher Secondary Education Orissa on the subject cited above, I have assumed the charge of special officer in respect of Anchalik Higher Secondary School Sirigida with effect on 25/8/2020 on the very same date. Forenoon, in order to exercise all the administrative financial power, so and so, so and so, so and so. So he has took over the charge on 25/8/2020 and issued the so-called, prepared the draft charge on the very same date and send it to the director. My response submission is sub-collector is not an ordinary, it's a very busy office. He took over the charge, assumed the charge of the office. If humanly, it is not humanly possible, he took the stock of the situation on the one date and prepared the draft charge and send it to the collector on the very same date. Director on the very same date.
Yes.
Everything done in one date. Though he has been appointed, said to have been appointed in 18/3/2020. But he has assumed the charge, his own admission, 25 6 মাস পরে কি 5 মাস পরে. So now, and more interesting, once the charge is framed, the charge is against me. Let us assume that it is not a charge, it is a regular charge. So charge has to be served on me first. It has never been served on me. On 25. It has been sent to the director. But before the director got the approval in October, 2 months thereafter. By that time, the government resolution has come, destabilizing all the governing, superseding all the governing bodies in that page 29 resolution. That I want to connect all these things now. So kindly my response submission at this juncture is, once he has took over the charge on very same date, admitted, and very same date he sent the draft charge, he never given it to me. And finally he is giving me, from in his counter only I got it and filed an amendment petition. It was not solved. But by the time it was solved on me, he was not in the office as a special officer. So therefore much has been argued on section 7A and 762. Provision. So my response submission is first, my lord, at this juncture, kindly turn to annexure N/4. Page 55, the first order, that on which date the director has allowed the sub-collector to work as a special officer. But he assumed the charge in August. Page 55, my lord.
Yes, absolutely.
In exercise of power under section 783 of the OE Act, the sub-collector Keonjhar is appointed a special officer in respect of Anchalik Higher Secondary so and so to exercise all the power of the financial power, administrative financial power of the college, said higher secondary college, under the provision of the OE Act through Constitution GB, till reconstitution of GB of the said higher secondary school. So this is the order given to the director on the very same date. Well, you see we can connect on 18/3, this is the first order. Now kind of next page 56. Very same date he has written to the letter to the sub-collector in the same allegation against the principal Anchalika Higher Secondary. I am directed to invite a reference on the above noted subject and to request you to initiate disciplinary action against the Girija Shankar Mahapatra, in charge principal so for negligence in duty, non-maintenance casebook and use of car biometric attendance. So what can you see? The allegation in one hand and 22/10/2020 he is approving the draft charge. So draft charge is stated to have been framed by the sub-collector. But before the draft charge could have come, he has preempted the matter on 18/3/2020 where appointing the sub-collector as the special officer to do the needful in the matter, even if letters he was ready. But he is saying these are the allegations against me for which the sub-collector is directed. So now my responsibility is, even if assume for the moment sub-collector is the governing body, sub-collector has not applied his mind as a governing body or the special officer. Everything has been put on him. A person directed to take charge of the governing body with the further letter on the very same date. This person has neglected his duty, proceed against him. And the sub-collector, what he is doing, he is taking charge 2 months after, on the very same date, without application of mind, without verifying the fact, because the director said, well, in 18/3/2020, he is framing the charge as if the charge was framed by somebody else, put to him for signature, and he is sending it to the director again for approval. So I failed to appreciate how who is person involved in this case, whether the director is framing the charge or the sub-collector or this governing body, let us say. But the rule provides, Rule 21 at this juncture, let us read one. Only the director, yes, director can proceed if there is a default. There is a default clause. If the governing body failed to take action against me, then director can show moto take action. But here is not that case. So only thing governing body has to do. And now governing body is doing is on 25/8/2020. So I don't know where from this director got this information on 18/3 and directing you proceed against him. And these are the same charges which has been from out, because it is a voluminous one, but almost the same charges what it is stated in 18/3/2020 letter. It reflects in that draft charge in Annexure 11A. And on the very same date, now I'll come to next page 57. Very same date, 4 letters he has issued. 18/3/2020, next letter. Special audit to the account of Anchalika College. I am directed to invite reference to the above noted subject and to request you to move the director local fund audit to conduct special audit of the account of the Anchalika Higher Secondary School Sigiria from 29th so. Government Higher Secondary School have notified above institution as an education institution for getting block grant as per the the date of release of the first block grant to those institution 21/9 and special audit may be conducted for the period so. So on the very same date, he has done the first appointed the sub-collector. Second, he has directed he proceed against the petitioner, and third, he has directed for a special audit against me. Because the college means because I am the principal, I am to be. Now, next page. On the same date, again another letter. This is to the principal, to me, because I am the principal on the day. Inviting reference, allegation against the principal. Inviting reference on the subject noted above, I am directed you to distribute the work of the account bursar, administrative bursar, academic bursar for smooth management of work of the institution. Further, you are directed to regular classes in CHSE norm, failing which your salary shall be stopped from the next month. Now, let's see. 3 things he says here. Again, you first distribute your works like account bursar, administrative bursar, and academic bursar. There is no such post designated for the institution for their administrative reason. They might have appointed somebody as an accountant, but there is no such in the statute. There are nowhere it is specified, or there is any circular to that effect.
Continue.
Yes. So now there is no such provision on the statute. So, but in one hand he says that if X is appointed as the special officer, in other hand he is directed to take action against me. In third, he is directing me, you distribute your charge to others, and at the same time you are directed to take classes, regular classes in CHS norm as stopped from the next month. The salary will be stopped from the next month. I don't know who made a complaint. Where is the inquiry that I am not taking classes, madam? Nothing is spelled out in all those letters that yes, something is wrong found against me. I am not taking classes. So a certain has to be given that your salary will be stopped from the next month. This is the letter. These are the 4 letters in one date. 18/3/2020. My note is to draw the conclusion. I am just to place it. Now, 28/5 is the draft charge. On the very same day, the sub-collector
25/8.
sorry, 25/8/2020 is the draft charge after about 5 months, madam. And this draft charge, the sub-collector admits that he has assumed the office only on the very same date. And this draft charge was approved by the sub-collector, annexure 10, that's 22/10/2020, after 2 months.
Yes.
So now by that date, so my response submission is, my first submission was, as my lord noted down, there is no concept of draft charge, there is a definite charge. So even if accepting it is a draft charge, so once the director sent, sorry, the sub-collector sent it for approval. So according to them, you will accept the version of the sub-collector or the director that it requires an approval of the director. Then now it has got the approval only on 22/10 October. And by that particular date, this draft charge would not have been accepted because by that date, this situation had changed because of that notification.
Yes.
Now kindly come to the notifications. 18/3/2020, he was appointed as a special officer. Now, kindly come to section 7A3. What has been read to my lord? Seven A says supersession and reconstitution of the managing committee or the governing body. Here the management can be superseded, and 7A3 says, 7A1 says the prescribed authority can supersede management. 2 says, so on the supersession, the prescribed authority shall take steps for reconstitution. 3rd says, during such period, this is the point now argued before my lord. During the period intervening the supersession or expiry of the term of the managing committee or the governing body, as the case may be, and its reconstitution, the power and function of the managing committee or the governing body, as the case may be, shall be exercised by such person or persons as prescribed authority may appoint. Now, according to this section 10A3, this notification 18/3/2020 was passed, nominating the appointing the sub-collector as the special officer for this institution. So now, once this will be accepted that from as per section 783, sub-collector becomes the governing body. So now he is to discharge the duty of the governing body. Now at this juncture, my lord, kindly have a glance to section 7A6. The other power with the government.
Yes, I've seen it.
Yes, the provide what does it say?
State government may reconstitute a government body, governing body.
Yes, no, it says, well, shall I read total? 6 faculty. The prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7A to continue in office till the governing body or the managing committee is reconstituted or appoint any person or person to exercise the power and discharge the function of the governing body or the managing committee during the intervening period. This is almost the power of the prescribed authority. It's been taken. So now, provided that the state government may reconstitute the governing body or the managing committee, as the case may be, notwithstanding that the term of such governing body or the managing committee has not expired, on such reconstitution, the existing managing committee or the governing body, as the case may be, shall stand dissolved. My response submission is this: the state government has got an overriding power. Even if the prescribed authority under even section 7C6 appointed somebody or allowed some other governing body to function, even if its term is expired, to function as the governing body, or constituted a governing body for the institution, because prescribed authority, the authority is the approving authority under section 7(6) also. In that contingency also, the state government has a overriding effect because this employed a notwithstanding clause. It has the power to supersede the dissolve the governing body and to make a notification in that respect. So now what is the notification manner? Page 29 once again.
Yeah, I've seen it, but why are you referring to it again? I've seen it, I understand it.
Yes, there were more satisfaction.
What is the point? Tell me.
ଗୋଟେ ଲାଇନ୍ ଟେ ପଢିଲେ ହବ ବୋଲି ସେଇଥିପାଇଁ ପଢୁଛି.
Yes.
In exercise of power conferred by subsection 6 of section 7,
Proviso to subsection 6.
sorry, proviso to subsection 6, because that is the only power clause. Pending reconstitution of the governing body or the managing committee, government after careful consideration will please to dissolve the governing bodies or the managing committee of the non-government. Now, my lord, dissolve everything, including the my response submission here in this.
But how is it applicable to you? But prior to this, the sub-collector had been appointed as the.
That is why it is applicable. My lord, the sub-collector was appointed as the special officer of the governing body on 18/3/2020.
By that time, there was no managing committee.
Yes, that is the prescribed
governing body, whatever.
Whatever it is, ma'am. So 18/3/2020 is the date. He was the special officer.
No, I don't understand.
He might have taken charge some other day. We don't mind. Only 18/3/2020. Take note of two dates.
Yes, 18/3/2020.
2020 is the special officer. That means he is the governing body.
So on that day, there was no governing body.
No, but he was the governing body. Now, by virtue of this notification, 8/9/2020, can you see the government letter? This notification is 8/9.
You mean to say his power, which was conferred by. I was taken away.
Dissolve. By
That you have already said.
that is my submission, madam. Whoever he is, whether there is a full-fledged governing body or half-fledged or a person continuing as the governing body. Now, by virtue of exercise of power, government has notified that everything is dissolved. That I want to only for this word dissolve. And how this is to manage, now they say that with the immediate effect, we have appointed the sub-collector or the nominated president as a person as a nominated as a president, not as the special officer. There is a distinction. Nomination of somebody as a president, maybe the sub-collector, and nominating somebody as a special officer under section 7(a)(3) or section 7(6), the main provision. This is the distinction. Since on 18/3 he is the governing body, sub-collector, by virtue of this subsequent notification of the government, now he is no more is the sub-collector. He is not the governing body now. At best, what he is now, by virtue of this notification, the sub-collector continue. I am currently next line. As to junior college, so power person development with immediate effect, dissolve with immediate effect, except the higher secondary school. Whereas sub-collector ADM have already been nominated as president of the governing body. But again, the word is president. He has dissolved everybody except where the sub-collector has been nominated as a president. Here the sub-collector nomination on 18, this is the final line, my lord.
Yes, special officer.
He is a special officer. He is the governing body, full body. But here, if he would have been nominated as a president, he would not have affected by this notification. But here you are the special officer. Now that power has been dissolved and you are no more continuing as sub-collector. Now by virtue of the second paragraph, the first paragraph is not the sub-president. So he is to go for dissolve, then second paragraph of this letter. Whereas the higher secondary school is situated as the district headquarters, additional district master of the concerned district acts as the president of the governing body or the managing committee till further order. In case of any district having more than one additional district master, the district master or the collector shall nominate one additional district master to act as the president of the governing body or the managing committee. Where where the higher secondary school is situated outside the district headquarters, the sub-collector of the subdivision concerned shall act as the president of the governing body. So now what the government has said, they have dissolved the governing body. Where there is already a nomination, he is said. Here there is no nomination as a president, sub-collector was a governing body. He is dissolved. Now by virtue of this notification, he continues to be the president of the governing body, not the special officer. So now my respect submission is, as the judgment of that Satya Sai or my lord's judgment, just as Satpathi's judgment, that Vajayanti Naik, everything. All the other judgments are there, many judgments on this now. But mere nomination of a person as a president, he cannot function as the governing body. So my responsibility now on 22/10/2020, the date the draft charge was approved. First, the draft charge is not acceptable, but even if it is charged on 22/10/2020, when the director is approving your draft charge, you cannot proceed against me because by that time you are no more in office. You are not the governing body. These are the final lines I want to draw.
Yes.
So therefore, on 8/9/2020 order takes away the power of special officer. So now therefore my responsibility submission is the draft charge which has served on me through this counter affidavit on the date it has served, it has to be given effect. But by that time he has no authority. So therefore I am questioning the validity of that charge because it is without jurisdiction authority. The other argument also I have advanced because the other day I was also submitting a judgment. My submission was, even if let us assume that he is the special officer, he continues to be the special officer, this notification is not there. My full submission, the judgment of this Hon'Ble Court, though it is in a other like case, that is cooperative, I have shown that judgment of that. Justice L. judgment 91. There the court has said if somebody is appointed as a special officer, he is to discharge the limited power, not all the powers of the authority. Because on the Cooperative Act also the same provision was there. It was dissolved AHS and all the officers have been appointed as a special officer to manage the affairs. But when the Hon'Ble Court said come to a conclusion, that is not permissible. In these circumstances, this even if he is a special officer, he cannot proceed against me. Moreover, even if he is a special officer, my lord, then the draft charge, the draft charge is unsustainable because the law requires that it should be definite charges. If the law requires a thing to be done in a particular manner, he cannot dilute it and say it otherwise. So that is also the law. And moreover, next, now, my lord, so far this other case is concerned with regard to the intercession, that the principalship is concerned that my senior is the petitioner and for their opposite party, that is Javier Poti. Here in this particular first case, Javier Poti, I made him a party because the direction was given to me to send the name of the senior most person, which has been stated by this Hon'Ble Court. There, this Javier Poti is undisputedly he is the senior person amongst all the staff members. So I got into but now he has filed a case, WPC 63342, saying it earlier that now my problem is not there. I want to continue as a principal of the institution. That is why the reference with regard to that circular and all this thing has been made. My local submission is, my lord. There is also another circular. I could not file it today. I brought it from the book. I'll give it to my lord. Here, he has given an undisputed fact. He has filed it. This annex of test 26, annex of 5, the second writ petition 63342. There, this is the unwillingness. He has read it. So I will not read it. He has given volunteer to propose my name to continue as the principal, and I have been continuing since 2011. So now he has also filed an affidavit that he has not shown because the other circular what I will give it to Velo. There the circular says this letter or unwillingness, the handwriting will not do. You have to file an affidavit to that effect. Here also, because that is a old circular, because the argument has been advanced by senior that this is in 2015, how it will give an effect from 2011. But there was another circular. This is the last circular. And there he has filed an affidavit, place 27. That also he has filed.
That is the one Savita Sahu.
That is
Savita Sahu. Another person is also there, two persons. He has given an unwillingness, and another person, Savita, was also there. He has also given an affidavit. There also she says that I am not willing to take charge. So these are the affidavit and documents before this Hon'Ble Court, and the government circular resolution in this regard. Well, 2015 resolution I have given. Once you have forgone for all time to come. That is the resolution. Now it has been stated that yes, that circular has been withdrawn from 2022. But all these actions were prior to 2022. Nowhere it is stated that how it will be dealt with. That is not there. Moreover, my lord, my responsible submission is, it is now we are in a premature stage with regard to this, whether I will continue in view of this or the senior most person, if he wish to come back, then whether he will continue, that is a subject matter of another dispute. But here I have been thrown out of the post, going to be thrown out of the post, not because of the circular, on the basis of some allegation. That is my submission to this entire petition is, had it been a case that yes, now senior person has come, government has changed the law, senior person can also change his mind and come back and sit in the chair. So what difficulty you have to leave room for him? It is something different. But now I have been directed to leave the post only with some allegation. That is why, my lord, that Satyajit Rai Chaudhary's judgment is squarely applicable to this, because the Satyajit Rai Chaudhary's judgment has also been upheld in the division bench. And we have to went to Supreme Court, that has also been upheld. So now that became the law of the land.
So SLB was probably dismissed.
Dismissed. So that now, because that is the law now for us. So that will guide the entire issue. Because this will be a stigma. This is my submission.
Hearing concluded, judgment is out. I think only file the submissions and memo citations, if any, within a week. Only I'm sorry, but I have heard 2 hours in one matter. And still Mr. Das says that I don't, he does not make any lengthy hearing. I don't know what is the meaning of.
Honestly.
No, you are heard at length. And you have argued for more than, if we combine the 2, it will be more than 2 hours. And I don't know what is the meaning of at length. Sir, I did a payment.
I followed one thing. That audit, one of the allegations I have.
Why should the court go into that special audit?
No, more Agur Day film, clarify.
You have referred to, yes. That's
regionally advertised because of the audit report. Now today also we got the audit report, special audit report.
We are filing what by way of a memo.
Affidavit.
CSK Das, counsel for the petitioner, files an affidavit, including a copy of the special audit report.
Yes.
Same Captain report.
Yes. They are made now. Yes. Now another. And that now only the audit has found that some advances are outstanding against the staff, including this here. Though some advance was against.
But in any case, on the basis of audit, no action can be taken.
Yes.
Simply on the basis of, I think audit, it cannot be taken.
That reason only, my lord, a disciplinary proceeding is essential.
Absolutely.
And that disciplinary proceeding has not seen it the lights till date.
All
Well, one Passover matter was there.
Passover Raja of nobody. On
item 10
item 10 we'll take it up next week. Next week, Mangalwar में से शुक्रवार में शुक्रवार कल मंगलवार को नहीं बेटा होच्छे ना
चित्र मुख्य कोटर तलोड़ श्रीवटा दे दूँ कोटे श्रीवटा जोड़ी
मतलब कंप्यूटर
मतलब that in item 10 I filed because that resolution number 30 and 40 was referring to, and it is not, it is missing from the record.
CSK Das, counsel for the petitioner, files an additional affidavit.
Which copy to?
After serving copy on the other side. Send the Captain report.
Copy the management bill, bro.
Copy number 3.
Management, waiting for the management.
All right, so Amar Ketra wala sab
14 or 18. Our data matter more. 14 or 18. See next week also.
next week. We continue the next week.
So 14 days of 3rd May.
We will take it up on 3rd May.
Oh, sorry.
14 or 18.
Item 11 by 16.
Next week.
Notice. 16 counter actually.
Yes.
Item 15 should
Item 15.
I don't know.
16 my senior was saying that he has got the Parvai's comment.
Let me see. Item 15.
Please, your lordship.
Lordship, I am appearing on behalf of Mr. S.B. Jana. On the last occasion, your lordship has directed to take instruction regarding that representation. Your lordship.
Yes.
My lord, in this case, my lord. In this case, my lord, when the case was filed in the year 2010, by that time, my lord, and the representation was submitted in the year 2001.
Yes.
By that time, my lord, these cases of the such type of teachers were also taken into consideration by the BDOs, block development officers. So she had made a representation before the BDO. But with respect to the present status, my lord, that we have given in the previous date instruction, my lord, that is 30th March 2024 by the BEO Jharsuguda, who in detail, my lord, has submitted that the present status, how after reorganization of the school mass education department, that has been taken into consideration by the BEO Kirimira. So, my lord, because your lordship specifically asked me to get the instruction from the BDO Kirimira, so I had contacted him, my lord.
No.
Yeah. He says, my lord, that in inviting a kind reference to the subject matter, I am to intimate you that this case is a very old case. The petitioner had given her petition in the year 2001, and the petitioner is the wife of a teacher. According to order number 7 dated 19/2/2024, I sincerely searched all related files, documents, including representation of the petitioner.
See again, block education officer to any partner, sir. He being the block development officer, an OS officer. You say I may be exempted. You obtain the information from the block education officer.
Eight are similarly.
You write it to such things to the High Court. Tell me,
Yes.
with your vast experience, how can he write that? He is a government officer. Block education officer is a government officer. He is the BDO. So if that information is not available with him and is available according to him with the block education officer, he should have obtained it. मत सारे अपना दाखो में खोजो तो बोले हाईकोर्ट को लिख दो.
It should not have been.
No, I treat it as a contempt. There has to be some respect to the rule of law, Mr. Patnaik.
Yes.
This cannot be done. I will express my displeasure. Sri Patnaik learned AGA files a copy of letter dated 18/4/2000. Here like this.
And prior to that, my lord, the previous instruction of BEO Jharsuguda, that says, my lord, that record has already been transferred to BEO Kirimira.
All right.
That was the previous instruction.
Since the previous order was passed, the judicial order was passed, therefore I said that you had already communicated to collector, to chief secretary, collector.
Jharsuguda.
You have to do it of immediate action.
Yes. No action will be taken, that I know, but let it be on record. I have dealt with the government officers, I know. But what is this? There has to be some respect.
Yes.
I actually suggested him to say that you could not found that particular document.
Say that I could not find.
In addition to that, my lord, another paramilor he added.
Mentioned 14.
17 posted to
After vacation.
Item 17.
17.
Item 17.
Occasion directed to file the.
No, the council has expired.
Mr.
Mahathi has expired.
My power is also there.
So, but somebody else had made a mention that he will be appearing in this case. Somebody in the morning.
My name is PK Panda.
It's there, but somebody made a mention in the morning. I have recorded the name also. On Nata somebody. Is it? Somebody he had made a mention that he has been instructed by the family members.
Fact that he has expired. My power is also there. Two powers are there, Mr. Mahanti and me.
All right, we'll take it up. After vacation, yes.
I don't know, 20.
Item 20.
Regarding the disengagement of GRS matrimony, this is covered by judgment of the son of court. Manas Kumar Swami. Regarding disengagement of GRS,
is it an appellable order? Yes. 2017 appeal.
The petitioner was engaged in Lordship may kindly see the agreement with the petitioner.
Annexure 1.
Yes, Miller. Page 23, Lordship may see the relevant person, Miller.
Page 22.
At page 12, Miller.
Yes.
The second party will be responsible for proper maintenance of accounts and database in the computer and to discharge the duties and responsibility under the NREGA or OREGS. The collector from CEO Jilla Parishad is also competent to take disciplinary action, including removal of or unsatisfactory performance, indisciplined or otherwise, after getting feedback from the concerned GP through a program officer. But the Lordship may see the disengagement order. I have been disengaged on the ground that at page 32, answer 5.
The last paragraph. Whereas although sufficient opportunity for putting forth each explanation has been provided to Sri Lalit Kumar Raut, the explanation submitted by him is far from being satisfactory. His achievement against the target given to him under NRHS regarding Aadhaar seeding, job card verification and generation of percentage 34%, 55%, 7% respectively. It shows that NRHS has not been properly implemented in his Gram Panchayat and has not been able to carry out his duties and responsibility as mandated by the Mahatma Gandhi National Rural Employment Guarantee Act 2005. I have not been assigned with that duty. My duty is to let's see, that's what I have submitted at maintenance of accounts and database, my lord. Yes. The implementation part is not interested to me, my lord. But I have been
Lord, your lordship, last time in that previous matter when in which case Mr. Rajit Roy was appearing, my lord, I had handed over a job chat of the GRS, my lord. And in that job chat, there are 54 type of works that has been entrusted to GRS why to perform his duty as per the agreement executed between the Sarpanch. Now, this particular work, that is, Lord, if your lordship will see the, your lordship have already seen the disengagement order. His performance are below par, Lord. Your lordship will see whereas his achievement against the target given to him under Manrega regarding Aadhaar seeding, job card verification, generation of percentage is 34%, 55%, 70%. Now, it is the stand of the petitioner that these three works are not within the scope of work as per the agreement executed by the Gram Panchayat. What if lordship will see that Lord have she would have GRS job check.
And note feedback also collected from the Gram Panchayat, my lord.
No, when was this issued by whom? What is the date?
This job check. It was 2006.
There's nothing mentioned here.
Let's say other file that in the other file I have given the main copy where the date has been mentioned. It's a photocopy. You will also see that
appeal lies to whom?
Director Manrega.
Director Manrega. Why don't you file appeal? These are all factual aspects. I know, I understand. Since 2007, you are fighting this litigation, but I'll condone the delay. I'll condone the delay because these are all factual aspects. Isn't it? Factual aspect, this court will not be able to go.
Well, this similar cases have been disposed of by this Hon'Ble court, my lord.
Okay.
And the writ appeal has been filed against that by the government, and that has been my instruction that has been dismissed, my lord.
What was decided? What was decided? By coordinate bench? By a coordinate bench?
My lord, justice bear showing.
Hello, coordinate bench is not.
Manas was fine case.
No, the Manas court is not decided.
That has been quashed, and
what was decided in Manas Kumar's line?
That
disengagement order has been quashed, my lord.
Lord, here what has happened, my lord, in Manas Kumar's fine case, the authority of the collector was questioned. Whether the authority, since the agreement was being executed by the Sarpanch, so therefore the disengagement order, whether the collector has the power or authority to disengage the GRS as per the act or the Lord, the resolution passed by the government, my lord. Now that was the subject matter question, and in that case, my lord, the Honorable Single Judge are referred to many other cases like Gagan Behari Patra, Amir Harijan, Binay Bhushan Behera. There are many judgments, my lord. In fact, this, my lord, I am just handing over one judgment of the division bench. WH 401, 402, 403 of 2017.
All on a sudden, the collector cut off opposite party number 2, white order dated so-and-so, that was received by the petitioner through his mobile WhatsApp, directed to BDA Tangi Chodwar to relieve all other functionaries working as GRS, whose names are not included in the order on or before 7/9/2009. So he received a relief order and therefore he had challenged. Your action is totally different. You were asked
without calling for the feedback from the Gram Panchayat, I have been disengaged, my lord.
No, true. But you were given an opportunity of hearing.
Yes.
You appeared before the collector. You submitted a
explanation. Yes.
Explanation. That was not accepted. He was not satisfied. Because it's all factual aspects. Whether you had actually performed your duty. So I don't think this is covered. This is not covered. This is on a different cause of action.
So may call it Monday so that I can.
All right. I'll call it next week, not Monday. I'll call it next week. But then, supposing the collector has committed some procedural error, then I could have considered.
Yes.
Since factual aspects are also there, I think then you can better prefer appeal.
So far as the authority of the collector to disengage the GRS is concerned, my lord, that has been set at test by the Honorable Division Bench, where exact same question was.
He is not raising that point.
Na sita pleading le sita main allegation tangor rokuchun je ye koi paribe. The collector has no authority to disengage him. But since now the question is whether these scope of work were included in the job set of the petitioner, regardless of the fact that these are not included in the agreement, the executed by the Sarpanch, my lord. Now my humble submission to lordship is that the job set is for all the GRS.
That is true.
They are not called for from the Sarpanch, my lord.
Yes, yes.
All these documents are not called for from the Sarpanch, my lord.
No, it is job set.
Because as per agreement also, agreement with the Sarpanch, my lord, the feedback has to be collected.
Agreement is always in general terms.
Yes.
It is always in general terms. When you are appointed to a particular post or assignment, specific job charter is always there.
Yes.
That is for everybody. Now the question is, you are. I have not gone through your pleadings, but now that Mr. Das is saying that he has also questioned the competence of the collector to pass the disengagement order. Where is stated that?
No.
That will not help you because already the division bench has held that the collector is competent.
Yes.
Is it not?
Yes, man.
So
Page para 7 the sister coach.
Para 7. No, he says the collector from C is also competent to take disciplinary action to remove him. After getting feedback from the concerned Gram Panchayat. So he says that the feedback was not obtained
From the Gram Panchayat.
Where is it mentioned that the feedback has to be obtained?
Yes, my lord, that is in the agreement, my lord. At page 23, my lord.
23.
Para 12.
After getting feedback from concerned GP through program officer.
My lord.
You find out?
My lord.
You find out?
Not.
You are Mr. Ponda.
NC Jana.
NC Jana. Mr. Jana, 11th counsel appealing for the petitioner submits that as per clause 12 of agreement, the collector is competent to take disciplinary action, including removal of the GRS for unsatisfactory performance after getting feedback from concerned GP through program officer. He further submits, in the incident case, the collector has issued the impugned order issued the impugned order forming an opinion regarding unsatisfactory performance of the petitioner without obtaining necessary feedback from the concerned Gram Panchayat. Learned State Council, Sri S.N. Das, Learned State Council shall take instructions in this regard and apprise the court, if necessary, by way of an affidavit. List this matter on 3rd May.
Interim order to continue.
Interim order to continue.
Item 21.
In these applications, the prayer of the petitioner transfer to case Raigada to Katak or Bhubaneswar. My orally prayer, if not possible to Katak to Bhubaneswar, any other place except Raigada with the expenditure of the petitioner, my lord. The FIR annexure one, so
the charge sheet?
Charge sheet, my lord, already collected. No. That's already collected.
Let's see the brief facts. Yes, ma'am. I wanted to see how many witnesses are there.
33 witnesses, madam. 33 charges.
They are all from Rayagada.
Yes, in and around, all from.
All our official witnesses already transferred.
No, official witnesses, but the private witnesses are there.
In my expenditure, except Rayagada, any other place, the FR addressed to collector and signed more than 100% local persons of the area, including Sarpancha and MLA also signed in the FR. My lord. I am now dismissed. Se jaga jai paruni mu.
ସେମିତି ଖାଲି ତ କହିଦେଲେ ହବନି ଯେ ଆପଣ ଯାଇପାରୁନାହାନ୍ତି ବୋଲି ନା।
My lord, political case, my lord, read the FR. Entire allegation against ଯେ ଖାଇବାକୁ ଦେଲୁନୁ, ପଇସା ବିକି ଖାଇଦେଲୁ, ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯାହା ଦେଲା ଆମେ ତାହା ଦେଇଛୁ। ରନିଂ ପେଜ 19 ଯେ ଶ୍ରୀଯୁକ୍ତ ଜିଲ୍ଲାପାଳ ରାୟଗଡା ଯଦି କିଛି ଫଲ୍ସ ଥାନ୍ତା ଦୋଷ
So there are as many as 33 witnesses, out of whom several are private witnesses, private persons. So it will be difficult for them to move out to another place.
Nearest Rayagada, my lord.
Nearest what? Kota Kona?
Rayagada जोड़ा nearest बरहमपुर हेले भी चलिबो।
Rayagada nearest Berhampur में.
My lord, मैं कहिबे जयपुर।
Jaipur भी नहीं. No, Jaipur में भी.
Jaipur is closer.
Jaipur में भी. Jaipur, Koraput. Koraput would be around 100 kilometers or 70 kilometers.
Rayagada को पाखो कोटा कौन मैं कहिबे my lord.
Parlakamudi.
Parlakamudi, my lord. Only
The question is, why should it be transferred? First of all, the court will
my expenditure.
the court should be convinced that there is a case for transfer. Why should simply on
My lord, say annexure 1, running page 19.
Yes.
The FR addressed to Srijukta Jillapala Rayagada, not to any police authorities. Our entire allegation against the political my lords. I am an outsider. Now I am a dismissed from job. More job nahi. ମୁଁ ସେଠି ଯାଇପାରୁନି ହାଜର ହେଇପାରୁନି ଏଫଆର ମାଇଲର
କାହିଁକି ଯାଇପାରୁନାହାନ୍ତି
କେତେ ଲୋକ ସାଇନ କରିଛନ୍ତି
ନା କାହିଁକି ଯାଇପାରୁନାହାନ୍ତି this court will direct the court will to positive protection
Congress person are
court will direct the court will to grant you necessary protection police protection
ମାନେ ସେଠିକି ମତେ ଜଷ୍ଟିସ ମିଳିବନି ଓକିଲ ଗେଣ୍ଡ ଓଭର ଏଭରିଥିଙ୍ଗ ଇଜ ଗେଣ୍ଡ ଓଭର ମାଇଲର କାହିଁକି ସି ଦି ଏଫଆର ଜଣେଇ ଦିଅନ୍ତି 23 page signed mailor.
For that, an inquiry has been made by officials, my lord, page 46, annex 8.
Political will be inquiry madhya hoichi.
District Social Welfare. Child Development
political case. No, I got a 10 crore जोड़ा parla committee mailor I agree.
The court will consider try to balance the convenience of both parties. You are one person. If you are granted protection, police protection, that will allay your fears that you will be harassed or any kind of trouble you will face. But so far as the other persons are concerned, all are private parties.
Police protection तो मिलो से अलग था. मतलब सेठी की just laws भी मते confidence दो ना सेठी. सेठी sir, my lord kindly see on page 23. All are void also signed this place.
Could be.
So my lord nearest place with my cost. More justice no.
Justice can be. You have faith on the court. Have faith in the court.
More cross करियो किए कौन करियो किए. You don't my respectful submissions parla committee to check 40 kilometers only. केते मुझे जानी नहीं है.
अन्ना तो 40 kilometers किंतु
केते मुझे जानी 50 की बात नहीं सही था. That are nearest any nearest place my lord with my expenditures.
No. So many persons. That is why I called for the charge sheet. कितने private लोग पहुंचेंगे देखो.
और private लोग 100 जन होते हैं.
ना हो तो. पवित्र चिन्ह सत्य
गुणपुर अच्छे पाखे जगह my lord. My associate says.
Students भी किसी अच्छी बहुत students हैं.
They are long since गलनी को तो रायगढ़ भी पैसे के ना दे रूम रूम पर nearest हो my lord. मुझे तो एक्सपेंडिचर पर बाटा भी ना. बाटा bear by the petition my lord.
No, that's it's not a question of bearing the
रायगढ़ को रास्ता पे 20 किलोमीटर 30 किलोमीटर दूर को गुणपुर गला 20 किलोमीटर अधिक पड़ियो. But local justice by my lord, advocates, MLA, Panchayat, all are
simply on such allegations.
That reflected the FR, my lord.
So what FR you are referring?
My lord, FR my lord.
FR is to be. FR this court will give a finding on the FR or what?
Charge sheet भी से prosecution के सही है.
से
खाया दलने हम बोलेंगे हम कतर मान लेनी.
How is serious allegation? बहुत serious allegation अच्छे.
Their statement.
Allegations are made girl students.
Yes, ma'am.
Of the residential school. You know what happens in those residential school.
But my resolution case registered after 3 years.
That's all right. It is your defense. You take in the trial.
ହଁ ମୁଁ ସେଟା କହୁଥିଲି ଗୁଣପୁର ଆସିଲେ ଭଲ ହେଇଥାନ୍ତା ଆମ ଖର୍ଚ୍ଚରେ ଆସିବ ଟିକେ ହଜୁର ସାହାଯ୍ୟ କରନ୍ତୁ ଲୋକ ମାସି ଯାଉଛି ପୁରା
No. ରଖନ୍ତୁ।
ମାନେ
I'll pass order. I'll consider, I'll pass order. Yes. Hearing concluded, order reserved.
Item 22.
May plus one. Transfer application at the instance of wife. Notice was issued and.
Nobody has appeared.
Yes, ma'am.
Who's it? You have appeared.
ମାଇନର ଗୋଟେ ଏନଦର ପ୍ଲେସ୍ ହେଲେ ବି ଚଳିବ ଆମ
No, no, ଦେଖେ ଆଜ୍ଞା ଦେଖେ।
Annexure 1, where the husband has instituted proceeding under section.
You have not, Mr. Sarangi, you have not clearly made out a case as to what is the danger that you apprehend. Simply making an allegation, a case cannot be transferred. You have to make out a case. You have to show that this is the danger that I.
ଅଛି ମାଇଲର କହିଲେ ମତେ ଗୋଟେ ମଣ୍ଡେ ଆସୁ ମୁଁ
Next week, assume. This matter next week.
ମାଇଲର ଦେ ଇଣ୍ଟିମାଟର କଣ୍ଟିନ୍ୟୁ
Intimator to continue. Intimator
ମାନେ ଅଛି ଯେ ଆଡଜର୍ନମେଣ୍ଟ ପିଟିସନ ଦେଲେ
ଅଛି ସେଥିରେ intimator ସେ ଅନୁସାରେ।
ଓବଲେଟ୍
Yes,
Yes, ma'am. Transfer application at the instance of wife. Yes, ma'am.
I am acting properly.
I know. You have received a copy of the transfer application. So what do you say?
Well, he is paying a husband file a divorce petition before the Lord Civil Judge Senior Division Gunupur. He is paying my lord pay transfer to G Udayagiri. I pray my lord kindly fix a both are teacher. He submitted that mention in his petition the opposite party is handicap 55% handicap homoplegia. The right side half a problem.
No, late.
He is fit for working, joining, and everything he is doing. I pray any middle place fix for other. ଭଞ୍ଜନଗରରେ ପାଖ ହବ 48 କିଲୋମିଟର ଜି ଉଦୟଗିରିରୁ ଗୁଣପୁର ବହୁତ ଦୂର ହବ କିନ୍ତୁ ଜି ଉଦୟଗିରି ଯିବା ପାଇଁ ସେ ଡରୁଛି ତାର ଗୋଟେ ଜିଆର କେସ୍ ଚାଲିଥିଲା ସେ ତ ବହୁତ ଟର୍ଚର କରୁଥିଲେ ବୋଲି ସେ ଡରୁଛି ତାର ଫୋନ କେସଟା ଜି ଉଦୟଗିରି ଚାଲିଥିଲା
Any chance of settlement?
नो माय लॉर्ड से ହେଇଥିଲା ସେକ୍ସନ 9 ରେ ସେ ପିଟିସନ ଫାଇଲ କରିଥିଲା କୋରାପୁଟରେ ହାଇକୋର୍ଟ ଡାଇରେକ୍ସନ ରେ ଟ୍ରାନ୍ସଫର କଲେ ଫୁଲବାଣୀରେ ଅର୍ଡର କଲେ ଯେ ସେ ସାଙ୍ଗରେ ରହିବା ପାଇଁ ୱାଇଫ କିନ୍ତୁ କୋଅପରେଟ କଲାନି ସି ମାଇଲ ୱାଇଫ କୋଅପରେଟ କଲାନି ଅଛି ମେନସନ ହେଇଛି ମାଇ ଲର୍ଡ ପେଜ 10 ରେ ଅଛି
कौन टीचर ଅଛି
ହଁ ଏ ଟିଚର ଆଉ ଲେଡି ଟିଚର
लेडीज
both are teacher
220 kilometer distance.
You are at Gunupur now.
And I am at parental house.
You are residing at
Jivdagir, parental house.
You wanted it to be transferred from
Gunupur to Jivdagir.
Gunupur to Jivdagiri. All right. And the middle place, what is the middle place? Gunupur and Jivdagiri are in Rayagada district.
Yes, madam.
But Bhanjanagar is in Ganjam district.
Ganjam district. 48 kilometer hଉଛି ଜି ଉଦୟଗିରି ମୁଁ ଆଜି ସକାଳେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଥିଲି ଆସ୍କା ହଉଛି 88 kilometer.
Of the honorable apex court 2001 page 3 paragraph 3 madam.
No, he is asking for a better place, Bhanjanagar.
No, yes madam. My humble submission earlier madam it was
From Gunupur to জি Udayagiri.
220 kilometers. Your lordship may
The case is at Gunupur.
yes madam. One thing
জি Udayagiri.
yes madam.
Instead of you wanted to be transferred to
Gunupur to Jivdagir.
জি Udayagiri. জি Udayagiri
Senior
division.
ଅଛନ୍ତି?
Yes madam.
ଆଚ୍ଛା.
One thing I may pray my lord. Earlier occasion it section 9 petition was transferred to the Fulbani. Lordship may direct that Fulbani my lord.
ଫୁଲବାଣୀ ହେଲେ ପାଖଟା ହଉଛି 20 କିଲୋମିଟର ଜି ଉଦୟଗିରି
There is no apprehension. Only
ଭଞ୍ଜନଗର ଚଳିବ ସେ ଆଜ୍ଞା
Where are you residing?
ଆମର ଯାଇ ଗୁଣପୁର ମାଇ ଲର୍ଡ ଭଞ୍ଜନଗର ହେଲେ ବି ମାନେ ଦୂର ହଉ ପଛ ସେ ଆସିବା ପାଇଁ ରେଡି ଅଛି କିନ୍ତୁ ଫୁଲବାଣୀ ଆଉ ଜି ଉଦୟଗିରି ଆସିବା ପାଇଁ ସେ ଡରୁଛି
ଠିକ
ତାର ସେ ଜିଆର କେସଟା ଚାଲିଥିଲା ଜି ଉଦୟଗିରି ତାକୁ ସେ ବହୁତ ଟର୍ଚର କଲେ ସେଠି ତାପରେ ଗୋଟେ ରାତିରେ ଗୋଟେ ଡିଟେଲ ରଖିଥିଲେ ଲୋକାଲ ପୋଲିସ ତାକୁ ରେସ୍କ୍ୟୁ କରିଥିଲେ କିନ୍ତୁ ଯଦି ଫୁଲବାଣୀ କରିବେ କରନ୍ତୁ କିନ୍ତୁ ପ୍ରୋଟେକ୍ସନ ଦିଆଯାଉ
You will move the court seeking protection whenever it is required.
Direct
This is an application filed by the wife
then my lord
seeking transfer of the case for divorce filed by her husband, bracket opposite party, being MAT case number 23 of 2023 in the Court of Learned Civil Judge Gunupur. 2. The Court of Learned Civil Judge Learned Senior Civil Judge G. Udayagiri. Stop. Sri S.K. Dwivedi, Learned Counsel for the petitioner, wife, submits
that Gurupur is at a distance of more than 200 kilometers from her place of residence, which is G Udaygiri. And therefore, being a lady, it is highly inconvenient for her to attend to the case at Gurupur on the dates of its posting. Stop. Para. Sri Umakanta Barik, Learned Counsel appearing for the opposite party husband, submits that his client is a partially disabled person.
Not his client, my client.
Oh, sorry. Submits that wife being a disabled lady, being a disabled lady. Sri Umakanta Barik, Learned Counsel appearing for the opposite party husband, submits that since a GR case had earlier been instituted against him, against his client at Koti, G Udagiri, he feels unsafe to come to G Udagiri if the case would be transferred there. He alternatively suggests that the case could also be transferred to Fulbani, which is at a distance of Kete, Jiudegiru Kete.
40 kilometer
ଜାଣିଛନ୍ତି କୋଣ
ଗୁରୁପୁର
ବେଶୀ ହବ ନା
30 କିଲୋମିଟର ଭିତରେ
ନାଇଁ ନାଇଁ
ପର୍ଟିକୁଲାର 60 ଖଣ୍ଡେ ହବ 50
which is at a distance of dash kilometers ଆମେ ଦେଖିକି କରିବା ଦେଖିକି କରିବୁ ପୁରା ଅଫିସିଆଲି କେତେ ଅଛି ଦେଖିକି କରିବୁ 56 kilometers Fulbani yes
yes my lord, only one thing this as the Fulbani is concerned your lordship that is family judge Fulbani
yes obviously wherever there is family judge
yes
it is further stated at the bar that there is a family court at Fulbani. Taking into consideration the submissions as above as also the convenience of the parties, this court deems it proper to transfer such and such case from such and such court to the court of Judge Family Court Fulbani. Stop. As to the apprehension of the opposite party husband, it is open to him to move appropriate application before the court below seeking necessary protection if such an eventuality arises.
One observation, my lordship, if my physical appearance may not be insisted.
Further, the learned judge family court shall not insist upon the physical attendance of the petitioner of the parties unless absolutely necessary.
Yes.
both husband and wife
ଗୋଟେ 15 ହେଲାଣି ଗୋଟେ ଟିଆରପି ଟା ଖାଲି ଲେଖିଦି ତିନିଟା ଟିଆରପି ଚାଲ ପରା ଦିଟା ଦେଇଛି ବିଶେଷ ପରେ we'll continue after lunch.
Item 24. My friend is appearing on behalf of opposite party and he wants to take instruction with regard to the settlement of the matter.
ଆଜି ଏଟା ହେଇଯିବ ଆମେ ଗୋଟେ ପଚାରିଦଉ କାଲେ ହେଇପାରିବ
You have appeared?
My lord.
With Officer Naik has entered appearance for the opposite party husband. Learned counsel for the parties submit that they shall take instructions from their respective clients as to if there is any possibility of settlement of the dispute amicably. List this matter. How to work? 9th May. Is there any interim order? What? Remaining matters will continue after.
take notice in the address given by himself in the petition below. Page 16, that was the petition case filed by the husband. My lord, he has given his address, home address. I will take notice on that address.
See, Pradhan Learned Counsel for the petitioner submits that the opposite party has. Where is that address?
Page 16 below, address of the petitioner is.
No, but the opposite party husband.
He has filed that matter.
I know. Was working in the merchant navy and having retired is residing in the address given by him in the petition filed by him in the court below. He further submits, comma, he would take notice on him in the said address.
Right.
Such being the case, let requisites be filed by Monday.
By Tuesday.
By Tuesday, notice be issued by speed post.
Right.
Fixing a short returnable date.
Right.
Release this matter on
8th May.
8th May. 8th May 2024.
Yeah, stay the further proceeding. There was an interim arrangement.
Let that in the arrangement continue. Yeah, arrangement in the meantime, if any application is moved for adjournment, you will like to call. But इथे किती गेला इथे सरी गेला सो अरे सर मग त्याला कोणती आरपीओची लिखते
So item number 6.
Yes.
May I please allow sir. Transfer petition from Lonanger's Family Court, Baripada to Lonanger's Family Court, Balesur, my lord.
My lord, I am the opposite party party. So I have no copy, any copy.
The notice has not been issued in this case?
No, my lord. Yes,
So you have approved so much.
Appear कर दीजिए तो notice हम पाएंगे.
Since opposite party has already appeared, let a copy of the transfer application be served upon his counsel by Monday. Leave this matter on
3rd May.
3rd May. Since you have appeared, is there any chance for mediation?
Sir, mediation तो हम yes.
You are ready? Yes. The notice will let a copy of them. It is stated at the bar that the matter that an attempt can be made to resolve the dispute between the parties amicably. No mediation. Stop. In such view of the matter, the High Court Mediation Center kariye. Let the records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear pursuant to notice received from mediator and to render full cooperation in the mediation proceeding. Is this matter master पर date करो? Vacation नहीं होती, vacation पर करो.
Vacation पर 21st June.
21st June.
it's also high there.
हाँ, आइए. Further proceedings in CP number 214 of 2023, pending in the court of law and judge, Family Court Baripada shall remain stayed till the next date. So till such time के लिए कैसे हो? बोला.
Okay.
Item 26.
Please, Lordship. Naturally, first two is come up for admission. This is against a confirming order.
What was 25%?
Lordship, appellant was
46. Yes, what it was?
actually this is a appeal has come up for admission. This is against a confirming judgment.
It has been admitted.
No, this is come for the first time.
Come for the first time. Yes. What is the matter about?
There is the plaintiff.
Was the plaintiff?
Lordship.
You are confirming or reversing judgment?
Against a confirming judgment.
Confirming judgment. Yes.
Lordship, the prayer before the trial court was for declaration that an unregistered partition deed dated 1/1/1965 to be valid. That was executed between the father of the present plaintiff and his brothers, or in the alternate, direct for fresh partition. Lordship, the core issue here was vis-a-vis two particular registered sale deeds, which was issued in the name of one Arjuna Tripathi, who happens to be the elder brother of the father of the present plaintiff. Lordship, it was contended that at that relevant point of time,
that particular properties, though had been purchased in the name of Arjuna Tripathi, had been purchased from the income of the joint family. And thereby, and it was being enjoyed and possessed by all the brothers combined. Subsequently, partition was effected in 1965, after which, by the document under Exhibit 5, had been readily unregistered, Your Lordship. Subsequently, the relevant co-sharers have alienated certain portions of the property in favor of defendant number 8 to 13. Now, defendant number 8 is difficult to understand. So you have to state the facts properly. I mean, who are the parties? Who are the members of the family? So, Lordship, one Kantha Tripathi was the common ancestor, survived by 4 sons. You have a genealogy prepared? It's a handwritten, yeah. And so, you must have second appeal admission by asking they will not be prepared. Anyway, place it. Lordship. So, Kantha Tripathi was the common ancestor. Yes, then survived by 4 sons. That's one Arjuna, Chakrapani, Narasimha, Patita Bhavan. Yes. Arjuna is the father of defendant number 1 to 4. Chakrapani is the father of defendant number 5A to 5B. Narasimha is the father of the present plaintiff, as well as defendant number 6. And Patita Bhavan, he was alive at the time of the, so he was individually made as defendant number 7. Yes. That's 2 sale deeds were executed, one in 1961 and one in 1962, by which certain properties were purchased. Sale deed. Who executed that sale deed? They were executed by different person, by which properties were purchased in the name of Arjuna Tripathi, the brother of the present plaintiff, father of the plaintiff, and one of the sons of Kantha Tripathi. This plaintiff was filed claiming that this partition amongst the sons of Kantha Tripathi, the common ancestor, was effected on 10/1/1965 by virtue of a mutual partition deed that has been exhibited as Exhibit 5. Admittedly, it's an unregistered document, Your Lordship. And prior to that, they were all in a common mess, and these properties had been purchased out of common income of the joint family, is not self-acquired property of Arjuna Tripathi. Thereafter, Your Lordship, all other properties, apart from this, there were other properties of the joint family. They were recorded jointly in the name of all the brothers, including properties purchased under one of those sale deeds. But one other sale deed of those 2 sale deeds, one of these properties were recorded jointly in the name of all brothers, and one of them were recorded individually in the name of Arjuna Tripathi. Arjuna Tripathi filed a case before the relevant mutation officer to record the names solely on in his name, whereupon it was order was passed in his favor ex parte. The present plaintiff challenged him before this honorable court. This honorable court directed him to approach the appropriate forum to challenge this, whereupon he had filed a partition petition before the commissioner, land record commissioner, during the pendency of which, now I must say something, Your Lordship, by virtue of that partition deed, that unregistered partition deed, the property, which is the subject matter of this writ petition, had actually been given to the father of the present plaintiffs. But pursuant to this particular recording, after the order of the land commissioner, the sons, the D1 to D4 of Arjuna Tripathi, present D1 to D4. What was the order of the commissioner? It should be separately recorded in the name of Arjuna. That's the property was made exclusive to Arjuna. Arjuna, Lordship. Then the D1 to D4, they declared that they would not allow the present plaintiffs to encroach upon that property, even though in the partition deed it was recorded it was decided that this particular portion of the property would be given to the father of the plaintiff and D6. Whereupon this particular suit was filed. So 2 cases were made. Firstly, it declared that this 1965 partition deed under the Exhibit 5, that to be effective and therefore binding upon all the parties, or in the alternate, break for partition. Now, what were the issues framed? Lordship, issues, 7 issues are framed. If the Lordship comes to running page number. So it revolves around the issue number 4. Whether the plaintiff is entitled to declare the partition deed dated 10/1/65 is valid and binds the parties. That is the issue. What does he have? The Learned Trial Court disbelieved the exhibit deed on the ground that it has not been registered. No, Lordship, that was secondly. Firstly, it was disbelieved on the ground that the father of the plaintiff had alleged, as per the plaint averment, he had died in 1957. So there would be no occasion for him to sign the deed in 1965, which was subsequently reversed by the appellate court, saying that this recording is on basis of wrong finding, because in the plaint it was said that the wife of
the father of the plaintiff. She died in 1957, not the father of the plaintiff himself. And then he was very much alive on the date of execution of this document. But it was said that since it's an unregistered document, so it cannot be proof of partition, it can only be proof of severance. The other co-sharers, they came up and said, the subsequent purchasers, I'm sorry, Your Lordship, the alienees, they came up and supported, yes, this partition deed has been executed because they had purchased the land on the basis of those partition deeds from the relevant co-sharers. The subsequent purchases or sale of these lands have been effected pursuant to that particular unregistered partition deed. So both the courts said that since this is not a registered document, we cannot place reliance on it on the ground that this is unregistered. However, they said that we can't also direct for fresh partition on the ground that some of the married sisters, they have not been made a parties. Whereupon, Lordship, my substantial questions comes up.
No. Let us go to the first appellate court's order.
Lordship, can I come to the running page number 32 of the Lordship's brief. Para 17.
Yes.
Lordship. Wherein the findings starts. First, vis-a-vis the issue of the enforceability of the receipt. In the instant case, there is no dispute between the parties that there was an amicable family partition between the successors and ancestor of the parties, namely Kantha. When the plaintiff has contended that the said partition took place in the year 1965, the contesting defendants 1 to 4 have contended that the said partition was effected in 1961. That portion I forgot to tell you, Lordship. It was the case of the defendants 1 to 4 that this partition had taken place, but it had taken place in 1961. And thereafter, these two properties were purchased, and thereby it was the separate property of their father. But no evidence has been laid by them, no documents have been exhibited, no witnesses have been produced by them. Yes, partition was effected in the year 1961 by virtue of an unregistered partition deed, right? Exhibit 7. This actually is a technical error because Exhibit 7 is actually the 1965 deed. But when Exhibit 7 is unregistered, it can't be held that there was partition of properties of late Kantha Tripathi amongst its successors. Though such a document, it can be said to be a family arrangement. So the learned First Appellate Court held, at best this can be considered as a family arrangement, but can't be said to be a valid. Thereafter, he goes on to cite the relevant judgments vis-a-vis the maintainability of a unregistered partition deed and its effectiveness. Thereafter, let's para number 18, the very next page. In the instant case, the evidence adduced by the plaintiff clearly reveals that prior to his birth, the successors of Kantha had partitioned their ancestral property and occupied their respective share of land. Beside him, he has not examined any other witness to substantiate the said partition among the successor of late Kantha Tripathi by means and bounds. Hence, in absence of such any such proof, I hold that the learned High Court had rightly observed that it can't be declared that the properties of late Kantha Tripathi was partitioned by meets and bounds amongst his successors by virtue of Exhibit 7. So, on this ground, it was said that Exhibit 7 being unregistered and no separate proof being made that this was actually given effect to, we cannot be said that the partition by meets and bounds.
What is wrong? The concurrent finding of fact. Why should the court interfere?
No, thereafter, having given such a finding, now, Lordship, my only prayer vis-a-vis the prayer of the plaintiff, seeking that a partition has been effected by virtue of that particular deed. Once you hold that particular deed is not a deed of partition, thereafter, subsequently to refuse partition, on the finding that parties agree that there has been a previous.
There is a finding that they had already partitioned their properties and were occupying their respective shares.
That's right. Because
I said come to paragraph 18. But in the instant case, the evidence adduced by the plaintiff clearly reveals that prior to his birth, the successors of Kantha had partitioned their ancestral property and occupied their respective share of land.
Yes. That
already partition cannot be subject to repartition. That is the law.
No, my case before the plaintiff's
previous partition is there here.
No, my claim is the previous partition was in 1965.
Maybe.
That's it. That was also prior to my birth. Once you hold that, no, this 1965 is not a partition. Thereafter, in absence of any express proof, because that's only pleadings by the defendants, saying that 1961 that, but they have not adduced any evidence, not examined any witness, not produced any documents to prove the same.
Now, having discovered in the 1965 partition, which is my only case, that the previous partition was taken place, had taken place, but it was in 1965 virtual exhibit.
Basis of evidence adduced before him, oral as well as documentary, which you say there is some mistake in describing the findings.
If you hold my partition deed to be non-enforceable, I had not placed anything else saying that previous partition had taken place prior to this particular document. And the defendants, while claiming that partition had actually taken in place in 1961, have not adduced any evidence. And the subsequent purchasers have said that yes, this partition deed has taken place because our sale, the purchase that we have conducted, have been sold by the respective co-sharers in pursuant to this 1965 deed. So once you say ki, yes, this deed is a family arrangement, at least you should have ordered future partition and not a partition deed.
The family arrangement, which is the family arrangement that the 65 deed.
65 deed, yeah,
which is by virtue of an unregistered deed. He says that it cannot be considered only for collateral purposes. To show severance of the status of the family, of the co-sharers. But prior to that, there is a specific positive finding that the parties confer had partitioned their successors of confer had partitioned their ancestral property and occupied their respective shares of land, which he obviously refers to 61 partition.
But my humble submission is that that is without any basis since 1961 partition. Nothing has been adduced. Nothing has been adduced.
On the basis of the evidence,
there is no evidence vis-a-vis the 1961. Like I said, no document has been annexed. No evidence or witnesses have been produced by the defendants. Nothing. Just a pleading in the WS. That's it.
So Confer died in the year 1957.
Confer died long back.
Yes, 1957. This is the finding. So Exhibit 7 is that partition deed.
That's
10/1/1965.
Gotcha.
Third son of Confer Pullo, who died in the US and subsequently in his favor, petition on the 6th. He doesn't believe that partition deed.
My humble submission is that if you disbelieve, then at least my second prayer should have been allowed to order a fresh partition.
No, he couldn't because he holds that partition was effected in 1961 and not in 1965, as we have been claiming on the basis of that unregistered deed.
Gotcha.
That is his finding. So let us find out how he has arrived at that finding. In the instant case, there is no dispute. There is an amicable family partition between the successors. He has relied upon the evidence of defendant numbers 1 to 4.
But admittedly, there is no evidence. They have just find the WS, Your Lordship. If Your Lordship kindly comes to page 63, wherein all the exhibits and...
Yes, Mr. Sahu, you are appearing. You are not appearing. Next case. All right. Let us see your substantial questions of law.
Lordship, that is a page number 17 of Your Lordship's briefing. Starts from 16. Which I would place reliance upon the first substantial question of and the third and fourth.
No. None of them are. None of them have been rightly framed.
The third question at least.
Third question, कौन?
The only vis-a-vis the issue of partition. All right, if you disbelieve my partition deed, I could always order a fresh partition to have taken place.
We can say whether the finding of the courts below that there was a prior partition, whether it is, supported by any evidence on the court. That is the only. What's your good name?
My name is Jayar Dev.
That's Jayar Devri, learned counsel for the appellant.
Dev.
There is the impugned judgment. Considering the submissions made and the grounds in the appeal, the appeal is admitted on the following substantial question of law. Whether the first the lower appellate court, whether the courts below
were justified in holding that there was prior partition of the suit properties in the absence of any evidence being adduced to such effect. Yes. Yes, issue notice to the opposite parties by registered post with AD, making it returnable within 4 weeks. The requisites be filed within 3 working days. Stop call for the LCR. Place this matter on. Vacation per
21st June.
21st June.
Item 27.
There is a delay of 5 years, my lord.
5 years.
5 years. Delay. I filed the petition with all documents. Gross negligence. Notice should go.
Yes.
All are related persons. Dependents. They have been guided by the lawyer. That I've explained in the petition with all annexures.
5 years.
5 years. That notice for the all are related persons. That I explained. I also include some annexures. They have received during COVID period some 2 notices from the court. They have gone to the concerned lawyer. They are engaged lawyer. The lawyer said that you leave this, you are not allowed to enter into the court. So I will take the steps.
All right, issue
On that
notice.
basis,
I hear it. 243 of 2024. Issue notice to the. What is the matter?
matter is there's a petition suit. Petition suit, and they have not accepted that there is on settlement was there.
Comparing or reversing?
It's a confirming.
Confirming judgment.
The defendant in the court.
You are the defendant. Yes. All right. Issue notice on the question of limitation.
On the question of limitation.
Yes, it's only on that. Let them appear. Let them appear if the court feels it proper to condone the delay, then only. By registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter on. 24th June. Chala, ako na siya.
Item 28.
May I please? Revision arises out of conviction under section 138 NI Act. In fact, on the last date.
Final revision, why has it come to me? My order. No, this shouldn't be listed before me. Criminal division mopo kaise?
Initially, recall application was filed. Modification that was disposed of.
So why has it come to me again? Criminal division, this is not in my assignment. Right? Endorsement bhi kichhi nahi chief justice ko na. No, dispose of wala ko. Application for modification was rejected.
Yes, ma'am.
Then? Yes. Why has it come? What's the issue? Noting to be ठीक नहीं. Because it was directed to be listed earlier. The modification application was rejected. Then what remains? There was a talk of compromise.
Yes, that is going on. In fact, 5 lakhs was the check amount. 2.5 lakhs already paid. So balance 2.5 lakhs. We had.
What was the final order passed in the revision? Was there any final order passed?
In this?
Yes, in the revision.
No, my lord. Only my lord, in the as an interim measure has directed for payment of 2.5 lakhs by a time frame. Since we have not deposited by that time frame, we have filed this. We have filed this. Not
that modification was rejected.
Reject.
Now
we get the 2.5.
Now the revision has to be
heard finally. Yes.
So it has to go to the assigned bench. Is this matter before the assigned bench? That's all. Yes.
Item 29.
On behalf of Mr. Samantra, I may please lordship.
Yes.
Well, here the petitioner challenge, though the challenge has been made for quashing of the proceeding, but without going into the same.
Why has it come to me again? 482.
482.
482 ମୋ ପକେଇ No, ମୁଁ dispose of କରିନି. Justice Mahapatra has heard the matter earlier. Oh, he has allowed it. No, that is the CRLMA.
Yes.
But nevertheless, why should it come to me? It was dismissed for non-prosecution. Restored by Justice Mahapatra.
Person was allowed by my
So it
Justice
should not come to
Mahapatra.
me. Wrongly it has come, no? Wrongly it has come.
Assignment.
My lord can also dispose of.
How?
Aguru dispose of.
No, it is more. I will dispose of it. Please this matter before the assigned bench. It is say. Yes, next matter.
Item 30.
30, there is an endorsement of the Chief Justice. Here there is a specific endorsement. That is why I am taking up this matter.
No, item 30 I want to withdraw my lord.
Permitted to withdraw.
Item 31.
31, my lord, lordship granted interim bail for a period of 2 weeks, my lord. The petitioner has already surrendered, my lord.
Yes,
It
yes.
is prayed for next week to produce the surrender certificate.
He has already surrendered.
Yes.
Ms. S. Das, learned counsel to the petitioner, submits that the petitioner has already surrendered to custody after expiry of the interim bail, and that she would file the surrender certificate by next week. Let's this matter next week.
He has filed an interim application. Your lordship was directed to take instruction on that interim application. Subsequently, it was extended for 10 days for obtaining that instruction. Therefore, it was come. He has filed an extension.
See, surrender question.
Yes, ma'am. He has that the petitioner has surrendered. Though a medical document was there, you lost to take instruction as a 10 days.
Next week, let her file the surrender certificate. We'll consider it. That also, let it be on record. Let that be kept on record.
Fine.
32.
Right, please. My limited prayer before your lordship for extension of interim bail granted by your lordship is help. Only praying before your lordship for last chance. He may survive. Last chance.
Before
last chance for a period. Because
693 copies of ganja.
No, that has been on merit. I have advanced my argument that 1 kilometer away from the road.
That I did not accept.
That is all.
I have not accepted. Go to Supreme Court. ये 600 kg गंजे यूज करते तो अपने सुप्रीम कोर्ट को
ये रास्ता करके छिड़ाई
हाँ
गोटे किलोमीटर में आइले 200 किलोमीटर
पूरा देखा जाଉଛି मतलब जल्दी देखा जाଉଛି कौन करथले
I have to get clear copy. If your lordship will peruse, the matter is otherwise.
Considering the submissions, 2 weeks further time is allowed to the petitioner. The interim bail granted, right, such and such order is extended by a further period of 2 weeks. It's made clear that no further extension shall be granted.
Medical certificate नाटा अलगा अछि
petition सारण मोर सेटा को धरुनी
And pardon madam, that item 29 earlier one 42 application was withdrawn before lordship of this present petition.
Alright, let the office make that note. Obviously, there is note देना थी सिर्फ
note तो cause list में नहीं किसी.
नहीं, they should have seen going through the office notes in the file. There is no such endorsement. So they should make that without which assignment I should not. Let them make that endorsement. I'll do it. All right. Item 33.
Same. Can it be next week?
No, let him find out. The court master will inform me so that he'll consider. How did DR को जाना दो?
Same there. Same there.
No, this is 8 one. 8 already been third time earlier extended.
Yes.
Considering no, considering the submissions, the prayer for interim bail is rejected. No, rejected. Yes. 34.
Item 34.
Correction be made accordingly. 35.
35.
May please your lordship, my lord. That matter, your lordship may remember, three dates.
लिस्ट स्लिप करिए इधर अच्छा yes
Not your lordship may remember that matter, three dates are different, my lord. Poisoning.
Last time you
Lordship
me
directed
take
me on
instruction. That whether any other medical documents are there or not.
There is no record of a treatment at Berhampur. So I wanted you to find out.
Madam.
Yes.
That I have instruction I have received, madam. The occurrences took place on 5/9.
Yes.
Then, madam, she was admitted at Berhampur. That is
when was she admitted?
Madam?
Kebe admitted?
On 6/9. On 6/9.
Very good.
Then, madam, there is also like documents on 8/9. Then 15/9. That documents was submitted when he was referred to High Tech. That there are in which hospital she was treated. That entire documents were submitted before the High Court, before the High Tech hospital, madam. This is the instruction and the document, madam, kindly see. And the statement is also that the complaint statement is there. So consecutively, she was treated. Some of the documents IO has received.
No, this is the 307 method.
Yes, sir. 307. Make that is the diagnostic says that there is poison is detected and mix the poison with water.
They could not. 4 numbers of Xerox copy of requisition slips. Except Sriti could not produce any other medical document relating to the treatment at MKCG, MCH, Berhampur.
And that's some of the documents that I have marked. That
these are all requisition slips.
Requisition slips in the hospital, man. And the entire treatment, the documents, it was submitted before the High Tech. And in the High Tech, this admission was on 26. Till that period, she was treated there.
At Berhampur?
Berhampur. Till 25, she was.
There is no record of.
That record was in High Tech. Entire the previous
High Tech record. High Tech
only that is discharge certificate is
discharge certificate. The previous history of our treatment
that was from the High Tech. If the IO will obtain all the documents from the High Tech, he will make an requisition to the High Tech hospital that you provide all the documents. Only these documents are available, which as IO seized, that was available before the.
This is because that man has an extramarital relationship with somebody.
But
how long has he been in custody? Charge sheet has been submitted.
Yes, your lords. 9/11/2023.
He is in custody. Charge sheet?
Charge sheet, my lord. Charge sheet 31/2023.
As directed, London State Council has obtained instructions from the IO that the petitioner was admitted to MKCG MCH for treatment on 6/9/2023. She was subsequently referred to High Tech Medical College, Bhubaneswar. The documents relating to her treatment at Berhampur were submitted in the High Tech hospital. The petitioner is in custody since
9/11/2023.
9/11/2023 in connection with such and such case. It is alleged that the petitioner mixed some poison in water and gave it to his wife to drink on 5/9/2023. The informant, his wife fell ill and was treated initially at Barampur and thereafter at High Tech Medical College. It has been alleged that it has been alleged by her that the petitioner had relationship with another lady with whom he was staying at Bhubaneswar. When the informant objected to such relationship, the petitioner is said to have assaulted her. Under such circumstances, the affair was lodged. This court finds that there is prima facie proof of the petitioner ill-treating his wife. But there is a considerable gap in between 5/9/2023 and 26/9/2023. That is the date on which she was allegedly poisoned and the date on which she was on which she was treated at High Tech Medical College. The particulars of her treatment in between are not forthcoming, which raises a doubt as regards the source of poisoning of the informant. Be that as it may, charge sheet has already been submitted. The petitioner has been in custody for more than 6 months. Taking into consideration of the other facts, I am inclined to allow the prayer for bail. Let the petitioner be released. Sir, weekly.
List item number 96.
One week after. That's straightforward. Yes, what else?
Item number 97.
Arjun. The Hataman.
97.
Item
98.
Again, I'll call out all the password matters serially.
Yes.
98.
My lord, custody since 5/2/2023. Offense under section 363, 65, 341, 343, 506, 372N. Read with section 6 of the POCSO Act.
And permitted to withdraw.
Item 100.
No, the earliest application was probably disposed of by me. The same application. List when moved. Is it one? Yes. 101.
Item 101.
101 20B 2C. I have filed an IA for interim.
Yes. What instructions?
The instruction has come that document is found to be genuine and she is suffering instruction. I was given.
The State Council has obtained instruction that the document attached to the interim IA, the document attached to the IA is genuine, and that the wife of the petitioner is ailing and under treatment at DHH Pulwani. Considering the above fact, I am inclined to take a lenient view. The IA is allowed. Let the petitioner be released on interim bail for a period of 2 months.
Oblace.
Leave this matter on bail application order को 2 मास पर करिए जून रे को
28th June.
28th June
Item 102. Right, please.
For 5% malad charge sheeted for the offense under section 302 34 IPC.
अच्छी charge ये case diary.
And the FIR against one CORAM and others. The present petition along with others malad implicated basing on the malad joint confessional statement and disclosure statement of the present petitioners.
Yes.
No circumstance, no direct evidence is available.
And
4 persons released on bail. My bail application rejected by the trial court.
rejection order shows another 4 application, 4 petitioner has been rejected.
Why was his application?
Only disclosure
statement and leading to discovery of the offense. That is.
And facts of the case is that the deceased had illegal relationship one Draupadi of the village of the present petitioners. So there is a dispute between the villagers and the deceased. On the date of occurrence, the deceased went to the house of the Draupadi, for which the dispute arises, and 5 persons assaulted. Thereafter succumbed to the injuries.
Since when are you in custody?
Custody means 14/5.
The custody since 14/5/2023 in connection with such and such case. It is alleged that the the petitioner is in custody since 14/5/2023 in connection with such and such case. The prosecution case is that the brother of the informant was found lying dead with several injuries on his person. The complicity of the petitioner and 4 other persons came to light during investigation. It is submitted that except for the confessional statement recorded under section 27 of the Indian Evidence Act, there is no other admissible evidence showing the complicity, showing his complicity. Stop.
The weapon of offense has been.
Disclosure statement.
Yes.
Further, the co-accused persons standing on the same footing have already been released on bail by the court below. But the petitioner's prayer for bail was rejected, keeping in view the disclosure statement. And State Council has produced the case diary. After going through the materials available therein, this court finds that there is a joint confessional statement of the accused persons before police and a disclosure statement under section 27 of the Evidence Act made by the petitioner. Save and accept the above. There is no other admissible evidence. Under such circumstances, I am inclined to allow the prayer for bail. Let the petition be released.
Item 103.
Petitioner number 1 is the father, 2, 3 are the sons. Allegation is that, my lord, one Punya Nahak and Gagan Nahak pelted the stone towards the house of the informant.
Is not available.
Appropriate case diary obtained. This matter, no?
29th April.
29th April. 29th April.
He got towards
29th April and period. 3rd April. No, 6th May.
Yes, filed since, my lord, 1 year back. ମୋ ପାଖରେ ଅଛି ଚାର୍ଜସିଟ୍ ର ସାର୍ଟିଫାଇଡ୍ କପି 161 ସବୁ ଅଛି. Lordship kindly see the FIR thereafter.
It has been listed.
Order is aligned next matter of land.
104.
104 ଆପଣଙ୍କର 104 ଟା ଆପଣଙ୍କର
ଆଜ୍ଞା
ପୂର୍ଣ୍ଣ
104 lordship taken up 2 weeks after. ନାଇଁ opposite let update case diary be called for.
Hey, 3% villager state.
Sure. Pass over. Perla. Call of the passover matters.
Passover item number 2.
Yes. Item 2.
Weekly matter.
My lord, on behalf of Hon'Ble Purna, kindly take this matter 2 weeks after, including my lord item number 64.
Item 2, you want 2 weeks after? Boss. Please, this matter 2 weeks after. Yes.
Passover item number 6.
Your matter? Oh, you have.
TB 2C, madam.
NCB?
My lord, NCB. Custody since, my lord, 13/8/2021.
850 kgs.
850 kgs. My lord, as per my instruction, my lord, for the last 3 years, my lord.
And West Bengal?
Yes, ma'am. One witness was examined. NCB, my lord, for that NCB is all, he has jurisdiction all over the country. And your lordship is not allowing the outsider. But since NCB is appearing, my lord, he has jurisdiction all over the country.
Very good argument.
So I
very good argument. You have made a very good argument.
So I pray, my lord, let him release an interim bail with any stringent condition. Since one witness examined and the NCB officers are not, my lord, responding at the order sheet, my lord. NCB are not coming up to give evidence.
No, sir.
Last.
So it is submitted by Secretary to Learned Counsel for the petitioner that the petitioner has been in custody for nearly 3 years, and yet only one witness has been examined in the trial. Stop. The court below is directed to submit a report regarding the status of trial. Is this matter on 13th May. We commence on 13th May. Yes. Mr. Ganalok Mati. Yes.
Passover item number 10.
The last occasion, the Lordship was pleased to direct the Learned State Council to obtain CD. This is a case, charge sheet has been submitted under section 364, 302, 109, 120B and 34 of IBC. The informant's case is that on 21/3/23, when his son was to attend call of nature, number of accused persons surrounded him and allegedly took away to the nearby Kaju field, where he was brutally assaulted. And when he was taken to hospital, immediately he was taken to Khordha hospital and thereafter AIMS, where he was declared dead. But so far my involvement is concerned, there is no direct evidence against me that I have killed the infant son. So many accused persons are there, and here, so far myself is concerned, conspiracy, allegation of conspiracy is there. And after examining the 161 statement, it is noticed that merely he was a attendant in the meeting which was called for to work out the activities, my lord. There are two rival groups in the village. Several criminal cases are there. In the month of January 23, there were case and counter cases against both the parties, for which GR case is pending. And the lordship will find from the records that I have been suffering from cardiac ailment since 2019, that I have made Annexure 2 series. Including myself, my lord, 2 other brothers are also.
What is your name?
My lord, I am is Vasudev Mania.
And Vasudev Mania, son of Satrugana, is the same person.
That we have already said.
That has been clarified. My name has been noted in the affair as Vasumania. Annexure 2 is my treatment papers since 2009, March 2019, my lord. I am under treatment.
Yes, what is the material against him?
My lord, I am dead. That is the The PM report is that due to injury, there is 12 numbers of injuries there. And reason is that due to dispute for Ganesh Puja between two groups. And leading to discovery to wooden sticks used for spade. It was
From the petitioner?
No, from the spot matter. It was seized from the co-accused Kalia. 2 pieces were seized from co-accused Kalia, another some from the spot. And whether those persons who were rescued the deceased, that Naru, his statement I am reading matter. ସନ୍ଧ୍ୟା 7ଟା ବେଳେ ଆମେ ଦୁଇ ଭାଇ ଜଙ୍ଗଲରେ ଅନ୍ଧାର ଭିତରେ କିଛି ଦେଖାଉନଥାଏ ଆମେ ପୁଅ ନାଁ ଧରି ଡାକିବାରୁ ସେ ଜବାବ ଦେଇ କହିଲା ଯେ ଦାଦା ମୁଁ ଏଠି ଅଛି ଆମେ ତୁରନ୍ତ ତା ପାଖକୁ ଗଲା ବେଳକୁ ସେଠାରେ ଥିବା ଲୋକମାନେ ଧାଇଁ ପଳାଇଲେ ମୋର ଭାଇ ନାରୁ ଓ ମୁଁ ମିଶି ଜଙ୍ଗଲ ଭିତରୁ ପୁଅକୁ ଟେକି ନେଇ ସର୍ବେଶ୍ୱର ମାନସିଂ ଘର ପାଖରେ ଖୋଲା ଜାଗାରେ ରଖିଲୁ ସେତେବେଳକୁ ପୁଅ ପଦିଆ ବହୁ କଷ୍ଟରେ କଥା କହୁଥିଲା ତାକୁ ସେଠାରେ ପାଣି ପିଆଇ ପଚାରିବାରୁ ସେ କହିଲା କି ରାସ୍ତାରେ ତାର ମୋଟରସାଇକେଲ ଆସୁଥିବା ବେଳେ ତାକୁ ଲାଲା ପରିଡ଼ା ପଛପଟୁ ଗୋଟେ ପାହାଡ଼ ପିଟିଲା ସେ ପଡ଼ିଯିବା ମାତ୍ରେ ତାକୁ କାଳିଆ ମାଣିଆର 2 ପୁଅ ଟିକା ନଣ୍ଡା ଓ ଲାଲା ପରିଡ଼ା ପାଲା ପରିଡ଼ା ଗାଙ୍ଗୁଲି ପରିଡ଼ା ବୀର ପରିଡ଼ା ଟୁନା ପରିଡ଼ା ଶିବ ମାଣିଆ ସୁନୀଲ ପରିଡ଼ା ଅଖୋଳ ମାଣିଆ ବାସୁ ମାଣିଆ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ଓ ଅନ୍ୟମାନେ ମୁହଁରେ ଗାମୁଛା ଗୁଡ଼ାଇ ପାଲା ପରିଡ଼ା ଘର ପାଖକୁ ଟେକି ନେବେ
What does he say?
ସେ କହିଲା ଯେ ଆମ ଗାଁର ବଳିଆ ସିଂ ସହ ଅସଂଘ ଯାତ୍ରା ଦେଖିବାକୁ କହିବାରୁ ମୁଁ ପଦିଆ ସହ ତା ସୁଜୁକି ମୋଟରସାଇକେଲ ବସି ଗାଁ ଦାଣ୍ଡରେ ଯାଉଥିବା ବେଳେ ପୂର୍ବ ଶତ୍ରୁତା କେନ୍ଦ୍ର କରି ପଲପଇଡ଼ା ଘର ପାଖରେ ପାଖାପାଖି ରାସ୍ତାରେ ଥିବା ହମ୍ପସରେ ପଦିଆର ଗାଡି ସ୍ଲୋ ହେବା କ୍ଷଣି ନାଲା ପରିଡ଼ା ହାତରେ ଗୋଟେ ବାଡ଼ି ଧରି ପଦିଆ ପିଠିରେ ପାହାଡ଼ ପିଟିଦେଲା ପଦିଆ ପରିଡ଼ା ମୋଟରସାଇକେଲ ପଡ଼ିଯିବା ମାତ୍ରେ ତାକୁ ଆମ ଗାଁର ଟିକା ମାଣିଆ ନଣ୍ଡା ମାଣିଆ ପାଲା ପରିଡ଼ା ସୁନୀଲ ପରିଡ଼ା ତୋଫାନ ପରିଡ଼ା ଧୁରୁ ବେହେରା ମୁନା ବେହେରା କାଳିଆ ମାଣିଆ ଶିବ ମାଣିଆ ବୀର ପରିଡ଼ା ପଞ୍ଚୁ ପରିଡ଼ା ଅନ୍ୟମାନେ ଘେରି ଯାଇ ଜଙ୍ଗଲ ଭିତରୁ ପଦିଆକୁ ଟେକି ନେଲେ
He doesn't name Basu Mania. No. The deceased himself has said that. That cannot be ignored. First or second or neither? The petitioner.
This is anticipatory bail.
No. First or second or कोई पे?
नहीं मुझे anticipatory bail बोले.
Then he has done the right thing. Because the previous matter I thought he gave a regular bail. Put up bail, put anticipatory bail, put up.
Government is always right.
The petitioner is apprehending arrest in connection with such and such case. It is alleged that the petitioner and several other persons of his village forcibly took the son of the informant to a nearby jungle and severely assaulted him, causing grievous bodily injuries, to which he ultimately succumbed. It is submitted that there was dispute between two groups of the village, which led to the quarrel. So, it is submitted by Sri Patnaik Lieutenant Counsel for the petitioner that his client is suffering from cardiac ailments, in support of which he has enclosed several medical documents to the bail application. That apart, there is a lack of clear evidence as to the involvement of the petitioner. Then State Counsel, referring to the case diary, and particularly to the statement of the deceased while he was still alive, submits that the petitioner was a part of the group that had assaulted the deceased. Stop. He, however, fairly submits that the other eyewitness who was present along with the deceased has not specifically named the petitioner. Considering the nature of accusations, the materials on record, and the materials on record, I am not inclined to grant anticipatory bail to the petitioner. However, first out similar.
So item number 31.
May I please? Second Johnny Miller, anticipatory bail. Madam, turn to page 14 to 18. 18, Madam, I'll have a glance to the page 18.
Earlier filed.
Yes, second.
Has been passed. Sorry.
The photograph of the petitioners. And what is the allegation? Allegation is that while the petitioners. See the second Johnny. Earlier matter is acted to surrender. Madam, kindly have a glance to page 18. This is the physical condition of the persons, petitioners, two persons, my lord. And so for the allegations concerned, it is alleged that they were, one is the secretary and another is the principal cum secretary of a particular college. And two groups of the particular college, my lord, teaching and non-teaching staff, they have made fight regarding their existence. And this honorable court has given the final verdict, annexure number 3, wherein the present complainant was also a party to it.
The earlier one was also in your favor.
Surrender, move for bail, it will be considered in its own merit.
So what is the difficulty in it?
Unless the clear got direction by see the condition. Page 18. Allegation is also not so serious. Teaching and non-teaching staff of a particular college, they fight to each other. This honorable court has given the final verdict, page 19 onwards. When the complainant himself was a party, complainant failed in the particular court to get his job. Now he has alleged that the entire thing document has been forged. When the honorable court has taken care of in this before the education tribunal, before this honorable court writ application, before this honorable court writ appeal, and the other groups of the particular college has been get their job. Now I was both the persons, one is the secretary, another is the principal cum secretary. They have a limited role. Now there it is, their claim the entire document has been forged. And this is the allegation.
But how can I modify it?
Because of this, my lord, I have constrained to approve this.
What?
About a 6 weeks before. About 6 weeks before, my lord, also kind enough to keep 2, 3, 4 matters hard and apart on the ground that whether the second application is maintainable. But unfortunately, because of the change.
Second application means when the first application has been rejected. Here, I have not granted you anticipatory bail. I have only granted you.
Respect, my lord. It's up to my lord. Either allow or reject. These are the two things. So, rightly, wrongly, my lord is partial order. I am not on that. But because of this, I am before by this court for just for a mercy up to these persons.
Because of what?
Because of the fact that their physical condition.
Well, Dion Goro.
Don't have Kichi Nai. Dion don't know the principal cum secretary, don't know not see the document, all these things are there.
Okay, we'll do one thing. Let him obtain instruction with regard to the physical condition. I will do.
Yes.
Sri Manas Kumar Chand, Learning Council of the petitioner submits that the petitioners were earlier.
Modification nullified. Say say previous.
Say the better one.
Then my lord may keep it to next week without any order.
I'll just simply adjourn it. You do that. That would be better. So that can be modified.
Because my lord has to pass a order. Yes, all right. Before my lord, my friends have also suggested this. You do this because it's all right. If I fail in my attempt, I will.
It did not strike my mind. No, it did not. No, frankly, it did not strike my mind. So everything not necessarily it will strike to my mind.
No, one my lord's mind is.
Base matter.
Yes. That in that anticipated bail application was not inclined to grant bail to the petitioner, my lord. And in the meantime, charge sheet has already been filed. That have annexed Annex 3, page 18. But,
No, I have granted you first or second or.
yes, my lord. Thereafter, my lord, charge sheet was filed. But Annex 3, page 18, deleting the offence, my lord, that is Annex 279, 337, 338, 294, and 506, my lord. Along with my lord, charge sheet file 307, 294, 506, 323, 325, my lord. In the case of the injury report I have given the Annex 4, my lord, that he has sustained a fracture injury, my lord, on the lower
thing.
my lord.
File and I will modify it. File and I, including this,
Yes,
the
my
change in circumstances.
Yes, my lord.
Because here what has happened is your application has technically not been rejected.
Exactly, my lord.
It has technically not been rejected. So how can a second application, it cannot be treated as a successive application. What you essentially want is a modification.
But after submission of charge sheet, my lord, deleting the offence, so it's my lord, the fresh cause of action file.
307 actually, 307 actually.
But injury, that injury, my lord, it's not in very.
That can be considered.
Fracture of blood leg. You cannot
You file an. You may seek modification of the order. You may seek modification of the order.
But you see the injury report I have annexed.
No, I'm looking at the injury report. Fracture and dislocation of lower third of right leg.
Yes, sir.
Swelling of dorsum of left palm.
At least 325. What not 307?
It must not be 307. 301. That. This is this matter in the week commencing.
29th.
29th.
I'll discuss for recalling.
No, you will right. Recalling no way. Modification.
Pastor right now 38.
और कोई तो वो जो रखी अपलोड करना था हैं आज सारा पेपर था
ना थिला है नॉन
ठीक है no that appeared none appears is this matter in the week commencing 29th April then
Pastor item number 42.
42 none appears is this matter in the week commencing 29th
Pastor item number 47.
same
Pastor item number 48.
May I please, Your Honor? This is a case under section 420, 468, 471, 120B and section 4 of OPID Act. This petitioner were remanded in this case on 31st May 2023. They were arrested in UW case number 14 of 2022.
UW.
Yes.
So, Mr. Patra is there. Yes.
In that case, my lord, your lordship granted 4-month anticipated, 4-month interim bail all the petitioner, my lord. And here in this case, my lord, as per the FR allegation, my lord, in view of the Rasmita Patra case, section 6 of OPID case will not applicable. Thereafter, my lord, 420 and 468 is also not applicable to this case, my lord. May I place the FR?
Yes, please.
Your lordship,
You are ready with the Mr. Patra?
What happened in the total million 131 commercial unit million. He has to deliver million. My submission, he has to give a list million out of 131 short million. How much he has completed till I will give an undertaking so that I will obtain instruction that I will. Out of 131, how much he has
previously, I
completed?
have given the details, my lord. Thereafter, I have also filed.
So instead of filing
this affidavit, I have already given to him, my lord.
No, this is the affidavit, my lord. That is not saying, my lord, how much unit they have completed. That is not mentioned here, my lord.
No, previously one chart.
No, we will update here. Mr. Mishra,
my lord.
Why can't you give another information so that he will obtain instruction?
Previously, I have given.
That is not.
No, 2 years not. Your lordship specifically directed to take instruction regarding that instruction.
Where is that? Where is that order? Let us see.
Index one.
The proper course of this order in.
I go to the
There is no such order.
Simply directed to take give a copy to him and he will take instruction. It has the previously I go to the
No, Mr. Mishra, there is no such order.
Total amount is 18 crores, my lord. We have completed the work for 15 crores, my lord. And rest of amount is there 3 crores, my lord.
So on that you obtain instruction.
Yes, on that light, my lord, interim bill in the previous case, my lord, the principal case, my lord. If your lordship allow to interim bail for a period of 4 months, my lord, I will file all the status report and the latest development.
Let me have the materials in my hand, then only I will grant you a So I will grant you only 2 weeks time.
Yes, within 2 weeks I will.
Then my lord, that bail application will be, interim bail will be in process. If he will not grant bail in this case, my lord.
No, total, you are involved in total 10 cases, my lord.
No.
One case is you have obtained interim bail.
In that case, I granted you interim bail.
Yes, my lord, 4 months, my lord. This is the order, my lord.
Another case, my lord. Total 10 cases are there.
That is in respect of this house, some Odisha.
Yes, my lord. In that case, this petitioner were remanded in this case, my lord. That is
I heard Mr. Senior Counsel was arguing.
That is the principal case, my lord.
No, on the ground that they will make sincere attempts to repay the amount due to already. You do one thing.
Yes.
You simply, I'll call it on Monday, from next week. You obtain instruction as to what exactly they have completed and what is the according to the prosecution. Okay. Sri T.K. Mishra, Learned Counsel for the petitioner, submits that out of 181, out of total construction amount, total amount of rupees 131 crores, the petitioners have rendered work amounting to
15 lakhs, my lord. Sorry, 15 crores, my lord. 15
and
crores.
15 crores.
Total amount involved is 18 crores. Out of 18 crores, my lord, we have completed the work up to 15 crores. I have also filed the affidavit to that effect.
The total outstanding amount, outstanding work is
15.65.
Exactly what?
15
crores. 15.65 million.
14.65 crores.
Yes.
Crores. We have to collect 2.5 crores. Only there is for completion we need only 1 crore, approx 1 crore. We have to
in the affidavit paragraph they have mentioned, my lord, 15.5 crore they have collected from the customers. Paragraph 6 of their affidavit.
6 affidavit.
I get.
Where is that affidavit?
I would copy the number.
No, affidavit they leave
More.
You are filing this affidavit?
Yes, madam. Today I am filing the affidavit. I have already given the copy, madam.
An affidavit has been filed in the court after serving copy on the other side. Inter alia stating that the project expenditure till date is rupees 15.65 crores out of total sales value of rupees 18 crores.
Yeah.
Then it's Sri Patra, Learned Counsel for the OPID, shall take instructions in this regard. With this matter next week. Next week, week once in Jotra, as we do.
Next week, weekly
supplementary
no, weekly asking for in the 7 दिन मिले ताकि तरह.
No, but
next weekly as well.
weekly as well. Coming
weekly list as मिले.
Weekly is 22nd as well. 22nd as well, so that. Yes.
So item number 51.
May please your lordship. The minute the petition is in the custody, my lord, on 9/6/23, my lord, and is the age is 80 years, my lord. The initial, my lord, on
yes, the child does not belong to the
madam. That is the biological report. But my lord, can see the medical examination report of the present petitioner who is about aged about 80, my
capable. That I've seen.
My lord. And he is a mentally disabled lady. In 161 statement and in 164 statement, she category stated the name of the patient.
Has the victim been examined?
No, victim is not.
Not it.
Will the victim be examined?
My lord, I am placing the medical report.
No, after examination of the victim, what is wrong on it?
My lord, victim is examined, my lord.
In the court?
My lord, no, report is not, my lord. My humble submission, my lord. The sole allegation of the information.
Sir, the victim has been examined.
My lord.
So let us have the deposition copy of the victim.
Submission letter.
Submission can you?
My lord, the deposition, the 164 statement of the victim.
164 recedes to the background once you come to the, once you say that the victim has been examined.
164, my lord. What is the statement of the?
Why should I go into that?
My lord, she only raised an allegation. The present petitioner is the father of the child, my lord. This is her only allegation. Only allegation, my lord.
The biological report, the DNA report is not in favor of in favor of the present petition, my lord. My lord, someone during the mental retard time, my lord, someone kept sexual relation with the victim, my lord. As a result, she became.
It is possible. It is quite
someone, my lord. But my sir, the informant, the victim allegation is I am the father of the child, my lord. So when the report is, my lord, releasing the DNA report is my favor, the present petition is excluded for father of the biological father of the child, my lord. So allegation is not sustainable against the present petition, my lord.
देखिए 164.
In the bail application, paternity cannot be determined. That whether the offense was occurred or not, that she has committed. That is on 164 statement.
164.
There's some allegations are there. That is why I'm saying I remember this case. So if she has been examined, let us see.
Let's see.
Yes, there is a medical treatment, my lord. The victim was not examined, my lord. Medical not treatment, my lord. Medical exam, my lord.
It is true, but
376 million without examined by the victim, my lord. So, the allegation against recent is not sustainable, my lord.
Sir,
So
you
without
know,
medical
you know the law, even without medical examination, only solely basing on the victim's version, also a conviction can be
Miller, he is the only person, Miller.
provided her version is acceptable.
Miller, her version, Miller, only I am the father of the.
No, no, other things are also
No, Miller, I am the similar.
No, ପଢନ୍ତୁନି ପଢନ୍ତୁନି ମୁଁ ପଢୁଛି ପରା ଏଠି ଆଉ ପଢିବ କାଇଁ ବଡ ପାଠ କାଇଁ ପଢିବ
ନା ମୁଁ ପଢୁଛି
ମୁଁ ପଢୁଛି ପରା ଏସବୁ ଲେଖା ହେଇଛି
କିନ୍ତୁ Miller 1811
why are you not waiting till the till her deposition? I'm just arguing it. You bring the copy of the deposition.
In the meantime, 1811 witnesses are examined and cross-examined, Miller. All the witnesses are done.
I just want to see the evidence of the victim. That's all. I will not.
magazine ମିଳିଯିବ
ଆଚ୍ଛା ସେଟା ଆସିବ ତ ଏତେ କଥା lose this matter.
1 year.
Lose this matter in the week commencing 29th.
Again.
29 April. Learned counsel for the petitioner shall produce the copy of the deposition of the victim. Yes.
So right now 58.
Yes.
Pray for adjournment, my lord, next week.
Next week.
So right on number 60.
Chhod de. None appears.
The 6th May.
6th May.
So right on number 61.
Please, beloved. Beloved, custody since beloved 1/1/2023, beloved. Yet not charge has been framed and successive bail application, beloved. And I have a copy of the trial court that yet not charge has been framed, beloved.
Are you rejected?
Beloved?
Opposing session में घाटो interim बिल गला तापरे
Status report was called for, I think.
So hearing on charge status report. Status report was called for.
No, my lord. Status report not called
Ah,
for.
Leonard Sessions is directed to submit a report in this regard.
I have annexed all the copies, my lord.
But you have annexed, but where is that? Because you said that this is the order. The previous counsel, Mr. Mahapatra, was arguing the matter.
Strength of prisoner petition, I'm.
That's all right. He says that the charge has not been framed as yet, apparently because of non-availability of the presiding officer.
That is also continuing, my lord. I am present in Jaipur court also today.
This is very. Submission of status report.
And in a similar ground, my lord, one accused, not related to in this case, my lord.
It is, as directed, it is informed by learned additional district and sessions judge in charge, Jaipur, that the case record has been received in his court on 8/6/2023 from the Court of Sessions. However, due to non-availability of the presiding officer because of the retirement of the previous incumbent, the case record stands posted for hearing on the point of charge. Yes. So earlier it was not rejected, earlier you were granted liberty to.
No, my lord, earlier applied, my lord, that was rejected.
No, but I find Justice Gauri Shankar Satpathy's order.
Yes, my lord.
Liberty was granted to you to approach the court below for interim bail. This was the order on 17/8/2023. With liberty to the petitioner to approach the learned court in session of the case for grant of interim bail. This was the previous order.
But petitioner has not applied, and in between cases transferred to me, my lord, not acquainted about that.
Yes. What is the quantity?
200.
200 of कौन हो?
Only praying for interim bail.
So interim bail, you already this court has granted you liberty to move the court below for interim bail. So how can I modify that? The coordinate bench has passed that order. You comply with that order, then come to this court. If you don't succeed there, already a coordinate bench has passed a particular order. It cannot be modified or recalled.
Yes, my lord.
To amount to going beyond it. So you simply take liberty to move.
That is better to me.
Learned counsel for the petitioner seeks permission to withdraw the bail application in order to comply with order dated 17/8/2023 passed by a coordinate bench of this court in BLAPL number 4507 of 2023. Permission is granted with liberty as aforesaid.
No blame.
So item number 64.
64 will be taken up next
week.
6th May.
6th May. We commencing 6th May.
So item number 68.
None appears. क्या फिर पुनः case है? None appears on repeated calls. On the previous occasion also there was no appearance. Further, the order dated 30/10/2023 passed by this court has not been complied with as yet. It is therefore presumed that the petitioner is no longer interested to pursue the bail application, which is therefore dismissed for non-prosecution. Yes.
So item number 69.
It is Seki. None appears. This matter will be commencing 6th May.
So item number 73.
Made periods. Your lordships, it is arising out of a complaint case, lordships. And petitioner has been remanded in this case, and petitioner is custody since 23/7/2021.
Yes.
And while though he was in custody since 2013, your lordships, in other similar cases.
It is a company, your lordships, wherein different depositors has been filed a complaint case, and that has been out of 11 number of complaint case, lordships. 8 cases he has been convicted, and he alleged to be a branch manager of the company. And out of conviction, lordships, 8 cases he has been released on bail by this honorable court in the appeal. Apart from that, lordships, 1 case he has been acquitted by the Grand Court below, and this is the case, lordships, where lordships offense 420, 406, 409, 425, 506, 34 IPC and 456 of PCMCS Banning Act and Section 6 of the PIT Act, lordships. Lordship complaint, lordships, this complaint has deposited 3 lakhs with the company. That is company name, say, Ramakrishna Electro Control Limited, wherein the director is the Chandrakant Bhargav Goel, and this petition is alleged to be a bank manager, lordships. And lordships, here also is out of 17 witnesses, charge sheet witness, 4 witnesses has been examined, lordships. The important fact is, lordships, IO, he has been examined. That is, lordships, I have annexed page
61.
61, lordships. There at cross examination, lordships, lordships will find at page 65, lordships. Page 65.
Yes.
The signatures of the accused Suresh Chandra Padi were not there in the seized share certificates, lordships. Page 65, lordships.
Page 65 paragraph.
First line.
The signature of accused Suresh Chandra Padi were not there in the seized share certificate.
Share certificate, lordships.
Yes.
And apart from that, page that paragraph 22, lordships, kindly say. Last line. I had not verified any document to show that the accused Suresh Chandra Padi was the branch manager of the Barampur branch of the accused company, lordships. This is the IO's cross-examination report, lordships. And the petition is custody since 23/7/2021, lordships. In this case, lordships, though he has been custody since 2013, lordships. And
what is the total amount involved?
Here, lordships, the complaint has deposited 3 lakhs, lordships.
Total amount is 5 crore 11 lakh 57,000.
And your lordships, in this case also, he has filed an NIA case, lordships, and wherein the director has been convicted.
Yes, Mr. Patra.
Milord. As it appears, Milord, he has involved in 19 cases, Milord. In 8, he has been convicted, Milord.
So we will not consider that because that is under in appeal, and so.
Yes, he has been a branch manager of the company, Milord. Statement says, Milord, he has collected through him, Milord. Money has been collected, Milord, and deposited in the some he has received and some deposited in the main account of the managing director of the company, Milord. And accordingly, Milord, he has arrested another case, remanded here case at 23/7/21, Milord.
So in this case, what is his financial liability? 3 lakhs.
5 crore 11 lakh, Milord.
Case,
yeah, in this case.
No, Lord.
In this case, the complainant claims to have paid only 3 lakhs.
Milord.
Here, the complainant claims
and others, Milord. Not only complainant, other. In this case, yes, just Milord. Rupees, charge sheet says rupees 3 lakh from complainant and 12,70,000 from his wife, Milord.
Wife has not filed any complaint case, lordships.
And Milord, in charge sheet page 27, paragraph 17.5, it has mentioned during the functioning of the company at Barampur, more than 300 persons have been cheated out, from whom 155 persons have been.
This is an economic offense.
Yes.
An economic offense. But insofar as this initiation of this complaint is concerned, some 3 lakh
and all.
So the charge sheet did mention 5 crore 11
Of
lakh.
course, because the other persons are also involved in during investigation, it came to light
Yeah.
that he has similarly cheated many other persons.
Miller.
So 5 crore 11 lakh 57,500. So is this linked to the 8 other cases in which he was convicted? No, this is separate.
Is separate rules. That might have been separate.
So charge sheet has been submitted. All right.
Trial is going on, Miller.
Trial is also going on.
Out of 17 witness, only 4 witnesses has
How
been,
could the IOB examined in first instance?
including the IO.
How would the IO normally is examined at the last?
Yes.
How was he examined in between?
Here, I has been examined in between, Miller.
Yes. But those 2 statements which Mr. Das has referred to
Miller.
in his evidence, that there is he does not, this person's signature doesn't find place in the share certificates.
But other statement are PW1 Miller can have a class PW1, 2 informant is there, Miller. Here categorically implicated represent petitioner, Miller. PW1 and 2 is there, Miller.
They have also not categorically stated these petition name lordships. They have
the company. They said about the company.
Company lordships.
And Sashikanta Party have issued receipt.
Kind of a glass.
He has been deposited through an agent lordships. That is also there.
Yes, Sashikanta Party, who is Sashikanta Party? You are the petitioner.
Yes, Lord.
He has issued receipts. That is what he is saying.
Receipt says, but that your lordship, IO statement is lordships, kindly see. There's not any share certificate name. There is no signature was there. There is the IO statement.
I deposit money by branch office. Suresh Chandra Party have issued receipt in favor of my deposits.
No, he cannot obviously deny that he has not received money. What is the amount, any proof of any amount transferred to his account, personal account?
No proof, your lordship. No cases also is there.
Personal account agent. But it has mentioned in page 20 of the charge sheet.
We'll take it up next week. You examine it again in detail. You also go through these the depositions, try to point out 1 or 2 points so that it can be considered. And since trial is going on, normally regular bail will be difficult, but we'll consider interim bail or something like that.
If in the meantime other has been examined, Miller, because Miller last person examined in 2023, 29 Miller. In between, some more.
Please, this matter in the week commencing 29th April. Land counsel for the petitioner shall inform the court as to if any other witnesses have been examined in the meantime. Yes.
So item note 79.
79, say 6th May.
My lord, on where Mr. Ponda kindly.
6th May.
So item note 87.
May I please, your lordship? The petition is in custody since 22/8/2023 for the commission of offence under section 21C of the NDPS Act. In the meantime, final pair has been submitted. My lord, prosecution allegation is like this, my lord. On 28/8
280 grams of heroin.
My lord.
Yes. 280 grams.
280 grams.
Yes. You have the case diary?
No, my.
What is that?
Final pair has been submitted.
No, all right. But was it recovered from his position?
Yes.
Directly position is 280 grams of powder.
After framing of charge, I may be given liberty.
Land counsel for the petitioner is permitted to, as land counsel for the petitioner seeks permission to withdraw the bail application with liberty to renew his prayer after submission of charge sheet. Permission is granted with liberty as aforesaid.
So item note 90.
I'll take on next week.
We commencing 6th May.
So item note 93.
Let us see. When appears 6th May.
So item note 97.
Same.
So item note 105.
Same.
Matter item number 42. Non-appears may be deleted.
42. 42 non-appears are there. Yes.
Next week, we will include their application will reduce a little bit to include those second offenses.
Yes.